Hello, court officer.
Yes, madam. ಏನ್ ಬೇಕಮ್ಮ ಜೋರಾಗಿ ಹೇಳಿಮ್ಮ what do you want? What is the urgency at 2:30? In which case? All right, tomorrow. Yes, Krishna. Any memo or adjournment? Wait, she'll call it out page wise. Wait, madam. Yes, page number. Yes, madam. After a week? All right. At request of learned counsel for petitioner, call this matter next week.
Number 37 to 47.
43. At request of learned counsel for petitioner. Release this matter after 2 weeks. Counsel for respondent is already informed and is present before the court. 46. Yes, Raju. At request of learned counsel for petitioner, call this matter after 2 weeks to report settlement.
Page number 8, number 48 to 58. Page 9, number 59 to 57.
I appear for the petitioner in. I appear for this.
ಯಾವ್ದು?
I appear for the petitioner, my lord.
Hmm.
On the last date, they sought time on 9. Now they're saying they filed NOC Wakalat. It could be taken up on Monday, my lord.
You want to retire from this case? What is this offense?
Atrocities, my lord. I have challenged the discharge application. My lordship has said the proceeding.
All right, we'll have it after 2 weeks. What's the great urgency?
My lord, in this matter, my lord, what has happened is, my lord,
Wait.
if it is kindly taken up on Wednesday, my lord, I'll explain it to the court. My lordship has looked in the documents and my
Sorry?
lordship has granted stay in this matter, my lord.
Granted what?
Stay, the stay of the proceedings, my lord, in this
So?
matter. I am for the complainant, my lord. It is a petition filed by the complainant.
Ah.
Challenging the discharge.
Because I have
application.
granted stay, I have to
That
hear
is-
it?
No, my lord. That's
Then?
not what I'm trying to submit.
Ah.
All I'm trying to say is that, my lord, discharge application was filed by the respondent. They had
Argue the matter.
my lord,
minutes.
they had separate this fact that they had approached this honorable court.
The urgency that I should have it at the day you say.
My lord, it was listed on 9. They sought for an adjournment without my
Matter, it's a
knowledge. Now,
23
my lord, they're saying that
He's seeking time. He wants to retire from the case.
if it is taken on Wednesday, my lord, I'll argue.
Sorry. Learned counsel for the respondent seeks time. Counsel for petitioner vehemently opposes. Her objection is rejected. Call this matter after 2 weeks.
Interim order may be extended.
Interim order extended till next date.
Oblige.
Madam, counsel for respondent seeks time on the ground that he would like to retire from the case. You want to retire? You're not going to come back in this case and argue again. My counsel, the party is not contacting.
Oblige, my lord.
ನೀವು petitioner ga? All right, at request of learned counsel for petitioner, call this matter after 2 weeks.
Lord, serial number 63. I am for the petition, Lord. So it's
Number
serial number 63.
63.
3. 2 weeks time granted, my Lord.
Request of petitioner counsel, call after 2 weeks.
Request.
Number 69, madam.
69.
Some personal information. Next week, partnered ಆಗಿದೆ ಹೇಳಿ ನಾ ಹೇಳಿದ್ರು. Next week.
You're for?
Respond.
It is for further argument.
ಆಗಿದೆ. I will inform next week.
Sir. You have argued on matters posted for further arguments.
ಹೌದು.
And you should finish it.
ಇನ್ನು petitioner
Where is Thumbigi?
ಹೌದು.
Where is your opponent Thumbigi? Prabhu Gaud.
He has engaged Nana senior counsel.
What is this matter?
130. 138.
Who has addressed? Both of you address arguments.
No, petitioner has to further. 1 week, next week.
All right, to call this man at request of counsel for respondent who submits that he has informed counsel for petitioner. All this matter on 25th.
Serial number 70. Next week, Milad.
70.
74.
I am for respondent in this case.
Let's argue the matter.
Next week, I was argued, last occasion, your lordship direct me to Milad produce exhibit D2, which is the identity
that
card.
is blank.
As how. That's
What
why the
happened? Where is that?
petitioner, last occasion also, I took took time to produce the same. The petitioner not yet given that particular document. That's why last chance, Milad, you have this matter next week. Otherwise, Milad, if the party petitioner is not come forward, I will go on with the matter.
All right. Yes.
I am for respondent.
Do you have that copy of D2, exhibit D2? They're not taken. Learned counsel for petitioner seeks further time to secure exhibit D2 as the same is not finding a place in the original records. Call after a week.
Your Lordship, serial number 72, Your Lordship. For the petitioner, serial number 72. So we have received NOC Wakalat in the last date of hearing. So yesterday we have received.
What is the offense?
Did not
Argue the matter.
So the next date of hearing, we will short accommodation. Short accommodation, we have received a certified copy yesterday. Your
No,
Lordship.
no. This is 2015 matter. Don't seek time in.
Short
15,
accommodation, we will.
Short accommodation is still 2:30. Argue the matter.
Yes,
Yes, next.
Page 13, number 80 to 88.
85, madam. We have to file application of section 3 and 4 of PO Act.
Which one?
85.
85.
Today I'm filing the application.
Ah.
One of the applicant is present. So another one is yet to come. So today I'm filing the application after serving the copy to the government.
What application?
Section 3 and 4 of PO Act.
POI. What is the offense?
Exams were.
Examination.
270?
406.
406. Impersonation.
Lordship I directed to
Yes.
1 week time.
Request of counsel for petitioner, call this matter next week.
Serial number 89, mile.
Serial number 89, mile.
We are reporting the settlement, mile.
Today?
Application.
Yeah,
Yes.
yeah.
Both
both the-
parties.
Put it. Any other matters in this page?
92
Yeah,
and
take up your matter.
92 and 94, my lord.
90?
2 and 94, my lord. Two matters.
Ah.
I am appearing for petitioner.
Yes,
Please grant to next week time, my lord. Senior, please.
KV Narsimhan.
92 and 94. I am petitioner Girish B. Baldare.
Learned counsel for the petitioner seeks time. Call this matter next week. Both the cases.
Serial number
92 and
91, my
94.
lords. For petitioner, my lords, I pray for a week's time, my lords.
You're not interested in arguing the matter?
Harvard, my lords.
Huh?
A week, next week, please, my lords.
Request of counsel for petitioners. Just call this matter next week.
92, 94.
Submission,
Data.
Your Honor. My lord. Serial number 64. It's for the admission, seeking time, Your Honor. 64.
Yes, 64. What do you want?
It's time, Your Honor.
You're for?
Admission, petitioner.
At request of counsel for petitioner, call this matter after 2 weeks.
Lords, I'm sorry, my lords. Serial number 39, my lords. I'm for the respondents, my lord. Kindly 2 weeks adjournment, my lord.
The matter is for admission. Petitioner has to argue
Lords, petitioner told me that he had held up in another court, my lords, out of station.
on behalf of petitioner. You're seeking time.
No, ma'am. No, I
You're
just,
respondent.
yes, ma'am. I'm respondent, my lord.
Why? He will tell you.
Just he has just informed me, my lord. That's all.
Request of counsel for petitioner, all this matter next week.
Obliged.
My lord, serial number 26, I am for petitioner.
Wait, madam. Yes. Correct. Settlement.
Funded. Total amount 75,000. Out of it 61,000. Maybe have cash paid. Cash paid on the last date of hearing they have.
What you filed? What you filed?
Application number 147.
Okay.
Compound the
What you filed?
total 75,000, out of which 14,000 is deposited for the trial court.
Mic on ಆಗಿದೆಯಾ ನಿಮ್ದು? ಆನ್ ಆಗಿದೆಯಾ?
Hello.
ಆನ್ ಮಾಡ್ರಿ. ಆನ್ ಮಾಡದೆ ನೀವು ಹಲೋ ಅಂದ್ರಿ ಏನು? Mics are given for lawyers. You come on ahead of them in front of. Take the mic, sir. Again,
Yes,
you're
sorry,
standing
sorry,
and
sorry.
looking at me. Don't behave like school child.
On. Sum of rupees 14,000 deposited before the trial court, mile.
25,000.
75.
You have received the entire amount.
14,000 deposited before the trial court, that may be released.
So that for 14,000 deposited, 61,000 is paid by way of cash that
Cash.
you have received. This petition is filed by the accused, being aggrieved by the judgment of conviction and order of sentence in CC number 1173 of 2012, dated 3rd day of August 2015, passed by the Principal Civil Judge and JMFC at Kadur, whereby the accused is convicted for the offense punishable under Section 138 NI Act and sentenced to pay a fine of rupees 75,000, out of which 70,000 was ordered to be paid to the complainant as compensation and rupees 5,000 to the state to defray its expenses. In default, to undergo simple imprisonment for 3 months. On challenge made to this judgment of conviction, in Criminal Appeal 127 of 2015, the appellate court, namely Second Additional Sessions Judge at Chikmagaluru, while order dated 6 February 2017, dismissed the appeal, confirmed the judgment of conviction passed by the trial. Agreed by the concurrent finding and judgment rendered by both the courts, the petitioner accused is before this court, challenging the legality, correctness, validity of the said judgment. Full stop. During pendency of this petition, petitioner and respondent have filed an application under Section 147 of NI Act to compound the offense, as they have settled the matter amicably between themselves by agreeing to pay the amount of rupees 75,000 towards full and final settlement. Full stop para. The petitioner has paid rupees 61,000 by way of cash on 4/9/24, which is received and acknowledged by the respondent in the presence of his counsel. The balance amount of rupees 14,000 is deposited before the trial court. Accordingly, both the petitioner as well as the respondent seek leave of this court to compound the offense. Full stop. Petitioner does not have any objection in the respondent withdrawing the amount deposited before the trial court. So also respondent does not have any objection in the petitioner being acquitted of the charges for the offense under Section 138 in view of the settlement and compounding of the offense. Full stop. Agree ಏನಮ್ಮ settlement ಮಾಡಕ್ಕೆ ಮೇಡಮ್?
Settlement
ಒಪ್ಕೊಂಡಿದ್ದೀರಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ಗೆ? ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ ದುಡ್ಡು? 50,000.
50,000 ಕೊಟ್ಟಿದ್ದಾಗ 75,000 ಆಯ್ತು.
50,000
amount is 50,000. Check amount is 50,000.
ಇಲ್ರಿ ಸೆಟಲ್ಮೆಂಟ್ ಅಮೌಂಟ್ಗೆ ಎಷ್ಟು? 60,000. ನೀವ್ ಯಾಕ್ರಿ ಹೇಳ್ತೀರಾ?
ಇಲ್ಲ.
Maintain, sir, you are an officer of court. You are with the court, not with her.
She's not understand the.
I know how to speak. Which language you want me to speak to her?
Right.
You should be a part of the system. There's a reason for asking.
Sorry, madam.
Don't make a mockery of the court, sir. You owe a duty to this court. Why I should ask her, I couldn't ask both of you. ಎಷ್ಟು ಬಂದಿದೆ ನಿಮಗೆ ಮಿಸ್ಟರ್
ಅವ್ರು ಕೊಟ್ಟಿರೋದು ಇವ್ರು ತಗೊಂಡಿರೋ ಅವ್ರು ಕೊಟ್ಟಿರೋದು ಪ್ರಕಾಶ್ ಅವ್ರು ಕೊಟ್ಟಿರೋದು ಪ್ರಕಾಶ್ ಅವ್ರು 75,000 ಕೊಟ್ಟು
Your petitioner accused?
ಎಸ್ ಅವ್ರು ಈ ಕಡೆ ಬಂದಿದ್ರು.
All right, you have given petitioner
Yes,
accused.
we have given 75,000.
Why they have interchange and standing there?
ಅವ್ರು ಆ ಕಡೆಯಿಂದ ಬಂದ್ರು ಅಲ್ಲಿ ನಿಂತ್ಕೊಂಡಿದ್ದಾರೆ.
ಎಷ್ಟು ಬಂದ್ ಸೇರಿದೆಯಮ್ಮ ದುಡ್ಡು ನಿಮಗೆ ಇವಾಗ? 60,000 ಬಂದಿದೆಯಾ? ವಾಟ್ ಅಬೌಟ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು?
ಟೋಟಲ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ ಕೇಳ್ತಾರೆ.
Total 75.
Court has inquired with the petitioner as well as respondent who are present before the court. They submit that they have freely and voluntarily signed the application, agreed to settle the matter without any force, coercion or undue influence. Accordingly, the application filed for compounding the offense is accepted. Full stop. Accordingly, I pass the following order. This petition is disposed. The impugned judgment of conviction, an order of sentence passed by the trial court in CC number 1173 of 2012 by Principal Civil Judge JMFC at Kadur dated 3/8/2015. Confirmed in criminal appeal number 127 of 15 dated 6 February 17. Passed by second additional session judge at Chikmagaluru is hereby set aside. Full stop. Next petitioner is accused is acquitted of for the offense punishable under section 138 of NI Act. Full stop. Respondent complainant who is physically present, identified by her counsel, acknowledges the receipt of ₹61,000 by way of cash. Full stop. She is permitted to withdraw the amount deposited before the trial court amounting to ₹14,000. Full stop. Trial court shall disburse the amount in favor of respondent complainant by way of electronic transfer on producing relevant bank details upon proper identification. Full stop. The bail bond of unsurety of the petitioner stands cancelled. Yes, please sign the order sheet.
That's it on the submission. Serial number 93, I am for the respondent. We have applied for some documents relating to this case to address the argument. So kindly give 2 weeks time, my lords.
Motion period is over, my dear friend.
Sorry, my apologies, my lords.
Make a submission at 1:30. Yes, call out the case. Sorry? This is some DV case, is it? Is it a DV case? Huh?
Now, they came to know that they are settled and they are living together also. But when officially they are not getting any communication. That's why you want to retire from this case.
Retire, who's stopping you?
That's why they are sending communication to now.
How long you'll keep taking adjournments like this?
So,
Been seeking time from past 1 year. Same submission is made from past 1 year. 1 year, case is going up and down. We are spending, you know, how much rupees? 5,000 rupees for one day when it goes and comes. Not bothered. The pendency is shown, like as if we are keeping the file with us. Or a duty. Counsel for the petitioner seeks time on the ground that he sent a letter or notice to the petitioner to retire from the case. Call this matter on 26th. 25th, 26th. When do you want? 30th.
Yeah, for respondent, my lord. Last
For the
occasion, the
petitioner, my lord.
petitioner undertakes to pay that
For the
amount
petitioner.
when he was produced before the court by the police. Last occasion, she has undertaken to pay the amount by an amount when she was produced before the Honorable Court by the police. Now she is not going to pay that amount.
Let me hear her. Let us say what she wants to say.
My lords, one submission, my lords.
Yes.
Rupees 500 has been paid. She just gave me the acknowledgement. I'll file it in the counter during the course. And with respect to 2 lakhs, apparently she has to get it from her brother who's in Mumbai. Because there has been Ganapati festival for the entire week. She was not able to contact her brother. She undertakes to give the 2 lakhs on 27th, my lords. By 27th, she will pay anta.
What is the outstanding, madam? There must be some huge outstanding amount.
I don't even have the file.
39 lakhs, my lord, by an amount. For the first 12 years, she has not paid up a single NP. Even she has not complied the orders of the Honorable Court regarding the deposit of 25%. Even first appellate court, she has not deposited. One way, another way, she is prolonging this matter, protracting, prolonging matter to harass this complaint. Twenty-two entry matter ಆಯ್ತು ಅಲ್ಲಿಂದನೂ payment ಇಲ್ಲ. Then matter was like not extended. The entry matter not extended. Then I went to the trial court and issue NBW. She was not available. NBW, she was not secured the under the NBW. Then matter posted before the Honorable Court. The Honorable Court issued NBW. Then she was secured.
You want the money or you are going to be satisfied by putting her behind the bars?
No, I want money, my lord.
Have some
Then-
patience.
Yes, I
I
want.
was undergone 50 days in JC. Ask
Yes.
her. You want to send her again?
ಅಲ್ಲ, so Monday ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು, Monday ಕೊಡ್ಲಿ ನೋಡೋಣ.
Have some patience.
ಅಲ್ಲ, I want money, but
Facilities will be
how she
there.
is harassing that man, that's my sincere submission before this Honorable Court.
All right, see, the choice is yours and hers. If she doesn't pay, I will pass an order. If you think you want money, then you have some patience. This is a recovery proceedings. It's not a totally criminal proceeding, IPC.
Monday.
You tell your client, madam, this is not acceptable. She has to pay.
I have told
Cannot
her.
keep taking adjournments.
I have told her, my lords, she said genuinely the banks were closed because of Ganapati in
Well,
Mumbai.
that's understandable. That's
Please, my lords,
understandable.
but 27th, she says, I will definitely pay.
But that amount you are paying is also only paltry sum.
Partly, sir.
There's some 40 lakhs.
39 lakhs, 5,000.
30 lakhs check amount is what I was told, my lords. I will talk to her again, my lords. But
When
27th,
27th.
please, my lords.
List it on 27th. If she doesn't pay on that day, coercive action will be taken.
Please, my lords.
Warning you now on.
I'll land. Please, my lords.
Sympathy shown by the court because she's a lady, aged,
She's having ailments. She was not
All right.
well.
so that cannot be taken advantage of. Law is same for all. Learned Amicus Curie representing the petitioner submits that the cost has been deposited to the Legal Services Authority. Same is taken note of. But Syed Umair has filed memo for retirement. Has she engaged any other counsel?
No, I had a counsel, but now I'm be going with her only.
All right, you'll
Yeah.
order. The memo of retirement filed by learned counsel Sri Syed Umair is accepted. And as this court is entered, Amicus Curie Learned Counsel Sri Archana came. Full stop. Counsel for the petitioner, in the presence of the petitioner, submits that she would make some payment on 27th. Hence, list this matter on 27th.
I'll advise her to pay me. Oblige.
Await. Report.
That petitioner statement. Needful is done. Process paid.
Kottidira?
Kottidis.
Paid.
Paid.
Learned SCGP submits needful is done. If same is an order issue to respondent. Ashinath. Needful done within 2 weeks, issue notice to respondent. Akhil.
For the Praxis Council, kindly have it on Tuesday, my lord.
For what?
PF for PF.
Kottidira, kottilla?
Alla, Madhuve is yesterday.
All right, I'll grant you a week's time, you pay the PF. Week's time is granted if PF, if needful is done, issue notice to respondent. One vara ide kodi.
Aye.
A week's time granted to rectify the objections. Hold on. Same order.
For the respondent, my lord. I apply for the petitioner, my lord. 10th October ಗೆ settlement payment ಮಾಡಿ settlement ಮಾಡ್ತೀನಿ ಅಂತ agree ಆಗಿದೆ. After that
ಆಗಿದೆಯಾ?
ಅದೇ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಕಂಪ್ಲೇಂಟ್.
I have no instructions, my lord. However, on the last date of vacation, that is on.
You deposited some amount.
ಇದರಲ್ಲಿ ಮಾಡಿಲ್ಲ.
Trial court records are sent alben.
10th ಆಗಿದೆ.
ಮತ್ತೆ ಡೆಪಾಸಿಟ್ ಮಾಡಿರೋದು ತಾನೇ ಸೆಂಡ್ ಆಗೋದು. You don't know.
My lord, on the last occasion, my lord, lordship had granted me the liberty to take up warrant on 39. And my lord, accordingly, we have applied for certified copy of this, that order. Not, we are yet to obtain that order. We'll initiate, my lord, we'll initiate appropriate steps before it.
You want time.
After vacation, my lord.
In fact, lordship had granted 3 or 4 weeks' time.
All right, you'll give him after vacation, you go ahead and do what you want.
Please, my lord, please, my lord.
Counsel for the petitioner seeks time. Or after 2 weeks.
Great.
Experience for petitioner, my lord. Amendment carried out, my lord, cast title.
First title carried out.
Carried out, son.
What is this? R3 and 4 are dead.
Yes, sir.
Wait, notice of 1, 2, 5, 10. ಯಾರ್ದಿದೆ? Sir, ಯಾರಿಗಾಗಿದೆ? She responded. ಹೇಳಿ ತಿರ್ಗಿ ಹೇಳಿ. ಸರ್ವ್ ಆಗಿದೆಯಾ? ಹ್ಮ್. 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 All served. What is this matter?
So, victim appeals. Actually,
We and
The-
court are awaited. Did. Correct, the last time memo. What is questioned here?
Sumit.
Question ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಇಲ್ಲಿ?
Sumit, ಅವ್ರು ಕನ್ವಿಕ್ಟ್ ಆಗ್ಬೇಕಿತ್ತು ಸುಮ್ಮಿ ಇದರಲ್ಲಿ ಫ್ಯಾಕ್ಟ್ಸ್ ಆಫ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಎವಿಡೆನ್ಸ್ ಮೆರಿಟ್ ಮೇಲೆ ಫಸ್ಟ್ ಅಪ್ಲೈಂಟ್ ಕೋರ್ಟ್ ಅಕ್ವಿಟಲ್ ಆಗಿದೆ ಸ್ವಾಮಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆಲ್ಸೋ ಅಕ್ವಿಟಲ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
Record. Notice to respondent 1, 2, 3, 4, 5, 6, 7, 8. 3, 4 bitakin, 3 and 4 bitakin. 1, 2, 5, 6, 7, 8. 9, 10 are served. Registry to show their name in the cost list. It is stated by virtue of a memo that respondents 3 and 4 are dead. Steps to be taken in respect of respondents 3 and 4. All after 2 weeks.
Directed me to serve the copy of the notice to the trial court. Served it and through the registry court. Filed a
In
memo.
offense,
Pardon?
what is the offense?
138 million. The amount is also been deposited.
If advocate is not appeared, what to do? You have to now take out
So
notice.
even this summons was also, notice was also served.
To respondent.
Yes. She
Which one
remained
is
absent. Then your lordship said, let the trial court advocate be informed. That has also been done.
Take out.
And amount is deposited on 18/9. I asked the party to get the receipt. I will file it in the counter once I receive it. Amount is deposited on 18/9.
What is this await police report in respect of?
Service, my lord.
Huh?
Service of notice.
Madam, whether check, what report has come that he served?
Non-cursed service again.
ಯಾರ್ಗೆ?
First time ಹೋಗಿದೆ, second time it is.
ಯಾರ್ಗೆ?
This respondent, my lord, earlier occasion she has been served. Then once again fresh notice is because she remained absent. Then your lordship said the let the go notice go once again and also directed me to take notice to the advocate.
So after service of notice.
Yes.
Nobody represented.
Nobody represented last time also.
Then why second time notice was ordered?
To give an opportunity, lordship felt that let me go.
What is that order?
Your order dated, my lord, 1980, your lordship kindly see.
Respondent PF paid notice issued. Refused to return to. Notice was held sufficient.
Please.
According, notice to
And also,
respondent.
my lord, my memo made dated 3/9/24 also be considered. I have served the notice to the
Returned
advocate.
as refused, so it is held to be sufficient as already passed by this court. By order dated 19/8/24. Registry to show the name of respondent in the cost list.
LCR may kindly.
All right. Admit. Secure records. You have deposited?
Please, on 18/9, my lord, I have
And
deposited.
counsel for the petitioner submits, he has complied the orders of this court with regard to deposit. What about next case?
Next case, the complaint is complaint is different, accused is the same. It's also notice is awaited. I have given the fresh address, notice is there.
Awaited?
Yes, awaited. In this case also amount has been deposited on 18/9.
Your notice is not served.
Not served.
Insufficient. You have to take fresh
I have
steps.
taken steps, my lord. I have given the fresh address, that is awaited.
Await notice.
Please.
Sharon PT.
I am for the petitioner, Milords, in
Yes.
serial number 13. Milords,
Yes.
on the last occasion, your lordship had passed an order that within 2 weeks, I'll have to make the deposit, failing which the interim order granted by this court will be vacated. Milords, we are yet to make the deposit. I was given instructions today morning that the client needs about just a week's time for him to make this deposit.
Is this
If
matter,
another week is afforded,
is this matter for admission?
Milords.
For the petitioner, my lords,
Yes,
seeking
Pal.
a week's time, my colleague who is appearing has met with an accident, my lords. There are only 2 of his objection remaining.
A week's time granted to comply.
Obliged.
Your lordship, in this matter, for depositing amount, your lordship, what happened, your lordship, the matter is posted on 9th. I have not received the copy, so that's the reason, your lordship, we can't pay the amount. And meantime, your lordship, he is suffering from dengue. So medical report also I have produced and application I have filed for extension of 4 weeks.
The time has expired.
Your lordship, 9th, this honorable court has passed order on 12th, your lordship.
14.
Page 5, your lordship, and we have received the copy on 13th, so that's the reason we have not deposited the amount before the court bill.
Got it.
So I'll grant 4 weeks, your lordship, I'll deposit the amount, your lordship, because a medical report also I have produced before this honorable court. Court below, your lordship, without the order copy, they are not ready to receive the amount.
Learned counsel for the petitioner. File this application seeking extension of time period to deposit the amount as ordered by this court. Right, it's order dated 14th August 24. On the ground that the petitioner accused suffering from dengue. Medical certificate to that extent is, medical records to that extent is appended to the application. Memo. Let's say it is an application. Accepting the same, 3 weeks' time is extended from today to deposit the amount. Let's call after 3 weeks. Await report. Connected matter, both are.
Same, I'm filing up.
Same order.
Please.
Akram Pasha. 1 week, a week's time granted to rectify the objections.
This case represent the petitioner, ma'am. 2 weeks time, ma'am. Because the certified copy of the order, my lord, has to be secured. That is not.
Week's time granted to comply.
Much obliged.
The petitioner in this, my lord. My lord, DDS was ready, my lord, but that file is not traceable in the trial court. So they have sought for 1 week's time to trace the file, my lord. That being the reason, the amount has not been deposited yet. I have the DD in my hand right now also, my lord.
Why can't you take out the notice to the respondent?
My lord, I'll furnish the fresh address, my lord. It has come with an insufficient address or something. I will take fresh steps, my lord, with regard to
So
that.
now
2 weeks time may be granted.
time is expired or you still have time to deposit?
My lord, 4 weeks time was given, my lord. It is, time is there.
You are supposed to say this.
Till 26th time was,
Order sheet for him.
28th was the order.
What do you want now?
Lord, the trial court has requested for 1 week's time to trace the file, my lord. It has been misplaced.
8. Time is still there.
Yes, my lord.
Don't
that
know.
is-
Call this matter next week at request.
My lord, 2 weeks time, my lord.
All right, 2 weeks.
I will deposit it in the meantime, my lord.
It is for
40
you to
days.
deposit within time, otherwise trial court will not take it.
No, my lord, I will do it.
All after 2 weeks.
Much obliged, my lord.
What is this objection on maintainability? Petition copy. There's no representation for petitioner. All this matter after a week, 2 weeks.
Petition
Number 20, I appear for the respondent, my lord. In this case, respondent number 2, I will undertake to file wakalat so far as respondent number 2.
What about 3?
3 is no more, my lord, he is dead actually now. Last week he met with an
What is the
accident.
offense?
Offense 138, my lord,
138.
that he has to pay a fine of rupees 30 lakh rupees.
Whose name? Vigneshwara?
Yeah, Vigneshwara is for respondent number 1. I am for respondent number 2.
All right.
I have my
Learned
wakalat has
counsel
to.
Sri Karnataka.
Yes,
P.
3.
P. Undertakes to file wakalat for respondent number 2.
Lord, 2010 transaction. Money was paid in the year 2010. Lord, a check was issued in the year 2007. and It's not been honored. Lord, there is a direction to deposit 50% of the fine amount. He has not deposited so far.
Already deposited now. Respondent number 3 is one of the son of the original respondent, is it?
Yes, my lord, yes.
Complaint.
Original complainant.
Who's reporting his death?
The mother and the other,
You have filed or you are filing?
I'll file, my lord.
File a memo.
File a memo.
Learned counsel for respondent number, respondents. Submit that respondent number 1 and 2, submit that respondent number 3 is dead. What about the LRs?
LRs are already on record, my lord, because unmarried bachelor boy.
And respondent number 1 and 2 are the LRs of respondent number 3. Memo is filed, same is placed on record.
Lord, my learned friend says
Number
that
1 and 2 shall be treated as LR of respondent number 3. Counsel for the petitioner to carry out the amendment in the first title of the petition and file a amended cost title. Yes.
my lord, in this
Okay,
case,
can
he
we-
says that he has deposited amount. My lord, these respondents may be permitted, complainants may be permitted to withdraw.
Deposited. Registry to show the name of learned counsel. So once Karnataka. Yes, you have deposited.
20% already deposited.
ಇಲ್ಲಿ ಏನಾರ ಡೆಪಾಸಿಟ್
ಮಾಡಿಲ್ಲ sir, ಮಾಡ್ತೀವಿ sir.
ಆರ್ಡರ್ ಆಗಿತ್ತಾ?
Order
Order
ಆಗಿದೆ,
ಆಗಿದೆ.
stay ಆಗಿದೆ, ಮಾಡ್ತೀವಿ sir. Stay ಆಗಿದೆ.
ಟೈಮ್ ಇದೆಯಾ?
28.
Time is there, you'll deposit.
29th, it may be posted on 29th, my lord, because 28th it expires.
Call on 30th.
Yes, yes.
This objection is permitted to complement 2 days. 1 minute. Yes, Madhukar,
I may permitted to complement within 2 days,
2 weeks to comply.
but suspension of sentence.
Huh?
So suspension is also start for my
You
lord.
have to first
Please,
comply.
Please.
I'll grant you 1 week.
But 2 days, my lord. Within 2 days.
2 days time granted, call on 24th.
Please.
Venkatesh. Ready?
Your Lordship,
For extension.
serial number 22, I'm appearing for the second respondent, Your Lord.
An MFA.
Yes, sir. Your Lordship was pleased to remand the matter after hearing both sides with the time-bound limit for disposal of the petition, Your Lordship. So the tribunal has sought for extension of time.
Peruse the letter dated 2/9/2024. Being satisfied with the reasons assigned by the learned civil judge JMFC Kunigal, senior civil judge JMFC Kunigal. This court deems it appropriate to extend the time further by 2 months from today, from the date of receipt of copy of this order for disposal. 2 months extended, man.
For the petitioner. Last date of hearing submitted that the matter is already settled.
Settled?
And the matter is settled. Even discharge deed is also produced. I have availed financial assistance from the bank. Respondent is the bank complainant. Notice was ordered and the notice had been to the bank. ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಪೊಲೀಸ್ ಅವರು ತಗೊಂಡೋಗಿದ್ದಾರೆ ರೆಪ್ರೆಸೆಂಟ್ ಬೈ ಗಂಗಾಧರ್ ಅಂತ ಇದೆ. ಗಂಗಾಧರ್ ರಿಟೈರ್ ಆಗಿದ್ರೆ ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಸರ್ವ್ ಮಾಡಲ್ಲ ನಿಮ್ಗೆ ಸರ್ವ್ ಮಾಡಲ್ಲ ಅಂತ ಗಂಗಾಧರ್ ಅವ್ರ ಮನೆಗೆ ಹೋಗಿದ್ದಾರೆ. ಬ್ಯಾಂಕ್ ಅವರು ನಾನು ಕೊಡಿ ಬ್ಯಾಂಕ್ ರೆಪ್ರೆಸೆಂಟ್ ಇಟ್ ವಾಸ್ ರೆಪ್ರೆಸೆಂಟ್ ಬೈ ಗಂಗಾಧರ್ ಅರ್ಲಿಯರ್. ನಾವು ಡಿಫ್ರೆಂಟ್ ಮ್ಯಾನೇಜರ್ ಎಸ್ ಕಮ್ ಅಂತಂದ್ರೆ ಇಲ್ಲ ಗಂಗಾಧರ್ ಮಾತ್ರ ಸರ್ವ್ ಮಾಡೋದು ಇದು ಹೈಕೋರ್ಟ್ ಇಂದ ಬಂದಿದೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅವ್ರಿಗೆ ಸರ್ವಿಸೇ ಮಾಡಿಲ್ಲ. Bank or nani, in fact, I have sent a letter to the bank also stating that the matter
No,
will be
this
taken up
is
today.
a cooperative society.
It is a society.
Notice has to go to the society.
Society only. It was earlier represented by one Gangadhar. He was the chief executive.
Gangadhar may live today, may not live.
Police have not served on him, on the bank. It says it will be served on Ganga. Our bank or receive ಮಾಡ್ತಿ ತಗೊಳ್ತೀವಿ ಅಂದ್ರೂ ಅವರು ಸರ್ವ್ ಮಾಡಿಲ್ಲ. Even I sent a letter to the bank also intimating.
What is the material you have produced to show that you have settled?
I produced discharge deed, please, on the last date of hearing.
Produced what?
Discharge deed.
Discharge.
Discharge deed. I had availed financial assistance. Home loan ತಗೊಂಡಿದ್ದೆ. I also mortgaged the property and the entire loan has been cleared.
What was the amount?
Amount was 15 lakhs.
They'll have to come and answer it.
Even I also sent letter to the bank also. They also received it, but they say that they.
Take out notice to the bank.
Yes, please.
Once again.
Yes, please. By hand, ಕೊಟ್ಟರೆ ನಾನು ಜಾರಿ ಮಾಡಿ.
Suspension is ordered.
No, because the entire amount is paid. I am not pressing I number 1 as of. If notice is ordered by hand, I will again once again.
Counsel for the petitioner to take out fresh notice to the respondent bank represented by its CEO. CEO either.
CEO.
Just take CEO, don't mention the name.
Yes, please.
All after two weeks.
Much obliged.
I filed an IE for dispensation of requirement of judgment, certified copy of judgment, my lord, in trial court.
IA 2 of 24 is allowed production of certified copy of the impugned judgment in CC. 526 of 17 is dispensed. 4 weeks' time is granted to produce the same. What happened to the notice served?
Notice of the IA served.
I am appearing for the respondent.
Yes, you're undertaking to file wakalat?
No,
You're
wakalat
Keshav
actually-
Bhatt.
Yes, I am appearing for Keshav Bhatt.
Ah. Yes. Suspension is ordered.
Yes, my lord. It's an old case, my lord, 20s.
Is this matter for admission?
I made an application, my lords. The matter was dismissed for non-prosecution, my lords. I made an application of recalling the order date in 23/7/2024, my lords.
Why it was dismissed, Mr. Counsel?
My lords. My lords, I made an application 31st July, my lords.
Why the petition was dismissed?
My lords, on that day, my lords, senior is in out of station, my lords. He was in native in Kundapur, my lords. On the 22nd, my lords, he came back from Bangalore, my lords. He was unwell on that day, my lords. 3 days he didn't come to the court, my lords. On that day, my lords, the matter was is not.
What was the stage? What was it?
My lord, it was listed for admission, my lords.
Admission.
On that day, my please, my lords.
Hmm.
Kindly allow the application, my lords, and
Argue the matter today.
my lords, and tomorrow, my lords, I will argue the matter, my lords. Please, my lords.
I'll call this matter tomorrow.
Please, my lords. Look, kindly allow the application, my lords, and that recall the order.
Argue the matter tomorrow, I'll allow it.
Please, my
tomorrow.
lords.
The respondent filed an IA for withdrawal of the amount deposited before the trial court.
Do you have any objection?
Filed the oblu.
They have
objections,
filed
my
a
lord.
formal objections. Already.
Kindly please.
What's the amount?
It's 1,70,000 has been deposited.
1,70,000. What is the total amount?
Total amount 3,40,000. Check amount is 3,40,000.
They have filed objections.
They have filed. I have filed for a withdrawal of money.
That is the objection.
It has might not be put up.
Have you filed objection?
Yes, my lord.
When?
10th, my lords. They have filed on 10th.
18th. 18th. my lord.
You have a copy of that. What is your objection?
Formal objections, my lord. They have.
What is your objection?
My lord senior is not well.
There's a notary.
It states that they have a good case on merits, my lords, and they have
Heard.
already.
Heard learned counsel for the petitioner and respondent on IA number 2. This application is filed by the respondent complainant for withdrawal of the amount deposited by petitioner accused. Objections are filed to this application contending that the petitioner has got good case on merits, and if this amount is ordered to be withdrawn.
So also, they also state that application is not maintainable.
The petitioner to recover the amount in case the petitioner succeeds in the matter. This issue can be addressed by imposing certain conditions. Accordingly, having perused the affidavit annexed to the application, being satisfied with the same, this application IA number 2 of 24 is allowed. Respondent complainant is permitted to withdraw the amount deposited by the petitioner accused. Full stop. Trial court shall disperse the amount in favor of respondent complainant by way of electronic transfer upon furnishing relevant bank details on proper identification. However, this order would be subject to outcome of this petition. In case the petitioner succeeds in the matter, respondent shall refund the amount along with prevalent bank rate interest. Respondent shall execute a bond to this effect before the trial court.
My lord said, this criminal revision petition be connected with another criminal revision petition, my lord. 1139 of 2024. 1139 of 2024.
24.
Please.
Call along with 1139 of 24.
I am for petitioner, my lord.
Well, application to withdraw the deposited amount.
Yes, any objection?
No objection.
Worker. This application IA 2 of 24 is filed by a respondent to withdraw the amount deposited by this petitioner. Learned counsel for the petitioner fairly submits she would not have much objection. It's the same would subject to outcome of this petition. Under the circumstances, IA 2 of 24 is allowed. Respondent is permitted to withdraw the amount deposited before the trial court. The trial court shall disperse the amount electronically, all that for whatever continues. However, this would be subject to outcome and other details. Yes. For the extension.
Petitioner, my lord. 2nd of this month, it has been added to, the time has been extended, my lord. 1 week time may be given, my lord.
Sorry?
2nd of this month, it has been, time has been extended for 15 days. We couldn't arrange the amount, my lord. The amount is 10 lakhs we have to deposit.
Extension of time for deposit, is it?
Depositing the 50% of the amount, my lord.
This is the second application you're filing.
Second application, my lord. There is a problem, my lord. That's why.
Just amount deposit ಮಾಡಬೇಕು?
10 lakhs, my lord. Nearly 10 lakhs I have to deposit, my lord.
When was the first order passed?
First order. Seven, 8, my lord. 7, 8, the first order was passed. 1 month time has been given, my lord.
You want 15 days time?
15 days, 1 week, next week only we will deposit, my lord. 15 days, next week only we will deposit.
Learned counsel for the petitioners filed IE number 3 seeking extension of time to deposit the amount. Having perused the affidavit annexed to the application, this court deems it appropriate to extend the time further by 10 days to deposit the amount. And the further order passed by this court on 2/9/24 would stay intact with regard to withdrawal. It's made clear if the amount is not deposited, As ordered, respondent would be at liberty to execute the order.
My lord, 29 serial number, I appear for petitioner in this case, my lord, 138 proceedings, my lords.
Learned counsel issue notice to respondent. Orders on IA number 2. Order of sentence. Dated 2/5/2017, CC 25399 of 15. Asked by 19th Additional Chief Metropolitan Magistrate, Bengaluru. Confirmed in Criminal Appeal number 1254 of 17. Dated 2/6/18. Passed by 65 Additional City Civil Sessions Judge at Bengaluru is hereby suspended. Petitioner shall be enlarged on bail subject to the following conditions. Petitioner shall deposit 50% of the fine amount, inclusive of any amount already deposited, before the trial court within 4 weeks from today. Petitioner shall execute personal bond for 1 lakh with like sum surety. It's made. If in case the petitioner does not deposit the amount as ordered, respondent would be at liberty to execute the order.
Much obliged.
For petitioner, my lordship. Await notice, await report, my lordship.
Wait, report.
Convicted under section 138 of NI Act, my lords.
Issue notice.
Yes. Sentences
on IA number 2. Order of sentence. Dated 28/2/2020. In CC 31 of 17. Passed by the Senior Civil Judge, JMFC, Somwarpete. Confirmed in Criminal Appeal 30 of 20 dated 2nd May 24. Passed by Principal District and Sessions Judge at Madikeri. Hereby suspended. Petitioner shall be enlarged on bail, subject to the following condition. 50% fine amount, inclusive of any amount already deposited. 1 lakh personal bond. In case the amount is not deposited, respondent at liberty to execute.
For the appellant in this case, petitioner in this case. Paper the respond. Accused revision petition, my lord.
Offense.
138.
Admitted. What is this? 2018 in the admit agila.
Already dismissed default agi restore. Once sir agli 23 nalli dismissed default agi restore agide. I am ready to admit.
All that admit list for hearing. All this matter on the first or second week. You have deposited the amount.
Please.
Withdrawn.
Permitted to withdraw.
You are not withdrawn.
Will not withdraw.
Just amount to
50%. 50% of this check amount.
what is the amount? Check amount.
3 lakhs. 3 lakhs.
Records are here.
Records.
Learned counsel for the respondent makes a oral request seeking withdrawal of the amount. You have any objection?
No.
Counsel for the petitioner fairly submits he would not have objection if a conditional order is passed accordingly. Following orders passed, respondent complainant is permitted to withdraw the amount deposited by the petitioner accused before the trial court. Full stop. Trial court should release the amount in favor of respondent by way of electronic transfer upon respondent furnishing relevant bank details on proper identification. Full stop. The trial court record shall be sent for compliance of this order to the jurisdictional trial court and return the same immediately after compliance of the order.
Much.
Petitioner. 138 proceedings. Concurrent finding. Check amount is involved in 6,25,000. Fine amount is 635.
Admit list for hearing.
My lords, I am for the respondent one, my lords.
Yes. What is the offense?
420 and 468, my lords.
For the respondent number 2, your lordship, filed wakalat in the registry. So you need,
For whom you filed?
accused number 2, your lordship.
What's your name?
Serial number 35, Imtiaz B.
Imtiaz.
Imtiaz B. I am his colleague, your lordship.
Yes. I am for the respondent one, my lords.
I'm
Accused
for-
number one.
Therefore, what is your submission? R2.
R2, your lordship.
What is your submission?
I have filed wakalat in the registry, your lordship.
All right.
So I need accommodation for file my objections.
What objection? What objection you want to file?
So your lordship, I have no papers, your lordship, in my hand.
You take the papers, no time will be given for objection. What are the objections to be filed in a criminal petition, revision? Your name is already shown. The
Yes, your lordship, in the last occasion, I have made submission.
copy or audio, is it? That CGP is directed to furnish one set of copy. Have you received copy, Shreyas?
Please, my lords, once respectful submission, my lords.
Hmm.
I've been acquitted in the trial court as well as the criminal appeal, my lords. And this is before my lords right now. So the CRL RP, there is very less scope, my lords. So that would be my humble submission right now, my lords.
That submission you can make when I hear you on the main.
Please.
Copy code okay. You can argue on the next date on merits.
Obliged.
All right.
Please hear me.
Admit secure records.
Deeply obliged, my lords.
Yes. No representation for petition on behalf of petitioner. Call later. Pass over.
Petition, my lords. Accused, 130 Deny Act, my lords.
Manjanna.
For the respondent.
All right. You have deposited the amount.
Oh, 50% department.
All right, admitted.
Call for it.
Secure records.
Much obliged.
38.
Permitted to file an application seeking some more time to deposit the amount. Difficulty is there for the petitioner. He could not arrange the amount.
2021 ಇನ್ನು ನೀವು ಅಮೌಂಟ್ ಪೇ ಮಾಡಿಲ್ಲ 2021 ಮ್ಯಾಟರ್
ಹೌದು ಅಲ್ಲ ಏನಾಗಿದೆ 74,000 ಟ್ರಯಲ್ ಕೊಟ್ಟು ಕಟ್ಟಿದ್ದೀನಿ. The lordship was pleased to pass an order that I should deposit 50%. That time will be there up to 28th. He is trying his best to arrange the money. He is finding difficult. 2,80,000 ಇನ್ನೂ ಕಟ್ಟಬೇಕು. I have sought time in this application. Lordship may kindly extend the time. I'll see that the amount is deposited. $280,000 ಇನ್ನೂ deposit ಮಾಡ್ಬೇಕು ನಾನು as per lordship's order.
ಅರವಿಂದ್ ದೇಸಾಯಿ. So you are supposed to deposit 50%,
28th ವರೆಗೆ time ಕೊಟ್ಟಿದ್ದೀರಾ ತಾವು
50%.
50%.
How much you have deposited?
74,500 in trial court.
Appellate court order.
Appellate court. ಇಲ್ಲಿ 280 ಕಟ್ಟಬೇಕು as per lordship's order. 28th ವರೆಗೆ ತಾವು time ಕೊಟ್ಟಿದ್ದೀರಾ. But
Correct.
it's difficult for him to arrange within that time. So I made an application to extend the time.
2 more weeks.
3 weeks would be better. ಸ್ವಲ್ಪ ಕಷ್ಟ ಇದೆ.
Work out. The Learned Counsel for the petitioner has filed an application seeking extension of time to deposit the amount as ordered by this court on 28/8/24. There is no representation for respondent. I peruse the affidavit annexed to the application being satisfied, the reasons assigned. Sufficient cause is made out to grant extension of time. Accordingly, IA is partly allowed. 2 weeks' time is granted, extended from 28, from when does the period expire? From the date of expiry,
28. From there you
the earlier order to deposit the amount as ordered. 2 weeks is granted
It's from 28. From 28.
from the date of expiry.
Yes. So,
Shankarachara.
Respondent in
Yes, Mr. Jagannath.
they had reported death of the second petitioner in this case. And also mentioned that the firm, which is the first petitioner.
This is
was-
that firm case.
Please, Mr.
You know,
But there's an amount in deposit, so I'm making an application that under the circumstances I be permitted to withdraw this. The amount deposit before the trial court. Madam. By order dated 24/6/2022, the suspension was ordered, directing them to deposit 50% of the
Who
amount.
has now one person, somebody has died?
Second petitioner,
Partner is the date, that is.
partner of the partnership
Dhananjay.
firm, which is the first petition.
Dhananjay, is it? The Dhananjay,
How?
he's dead.
He's
You are representing him.
dead.
You are representing both.
Company is in the year 2015 or 16 itself is dissolved, I think so. Now we are also in
The partnership firm.
form itself is dissolved in the year, but they are also aware the same, respondent also aware the same. That is the partnership form.
Who is the other partner?
We don't know, because I not get any instruction from the client also, but only thing that I got the death certificate and I produced in last date of hearing.
When is it reported, Mr.
Well, they filed a memo dated 28/8/2024,
I given death certificate.
producing the death certificate of the second petitioner.
So now you have to bring the partner to, for your petition to survive.
Matter maybe close reserving liberty them to otherwise, because we don't have any instruction from any client.
I'm also, she had made a submission that was, the partnership itself was closed in 2015.
Correct.
On
Now, is there
inquiry,
any
I-
assets of the partnership?
Look, there in my affidavit, I've stated seeking permission for withdrawal.
All right, I'll
If
permit
at
you.
all there is any assets, I'll take.
Because now that they have not brought on record, even
Correct.
after the last date.
Under
she
these
is not taking-
circumstances, it may be closed, giving me liberty to take.
Shall I do that?
Because they don't have anything at all. We have the instruction that in that file in the 2016 itself is company, firm is closed. Thereafter, I received the death certificate, now we are contacting the client, but nowhere we are getting the information from them regarding the partnership firm or else.
No, but where is the letter sent by you to your client? Tomorrow you will file it against you.
Then I'll send notice to her, then after I'll.
Better do that. Otherwise, he will make allegation against you and file again. It will come before the court again, recall.
I'm submitting that
Permit him
because
to withdraw the amount.
this because already 50% they have deposited. That your lordship may be directed them let they close because the check amount they're alleging that is 4 lakh, I think. So.
Record, learned counsel for the respondent has filed IE 1 of 24 seeking withdrawal of the amount deposited by the petitioner. Have you deposited?
Yes, your lordship, 50% depositing.
Yes. Counsel for the petitioner fairly submits she would not have much objection if the same is subject to outcome of the petition. Full stop. I have perused the affidavit annexed to the application, being satisfied with the reasons assigned. The application 1 of 24 is allowed. Petitioner respondent is permitted to withdraw the amount deposited by the petitioner accused. Full stop. Trial court is directed to release the amount in favor of respondent complainant by way of electronic transfer.
Please.
On the respondent producing relevant bank details upon proper identification. However, this order would be subject to outcome of this petition. In case the petitioner succeeds, respondent would refund the amount along with prevalent bank rate interest. Trial court records are here.
Yes, my lord.
Yes.
Registry to send back the trial court records to the jurisdictional trial court. 2 weeks time granted to the petitioner to take steps regard to the LRs or the other partners of the petitioner.
Please. Public.
In offense, Mr. HCGP.
Offense 406, 420. The trial court has taken cognizance after perusing the statement of witness and also record, material on record. Issued summons against the accused number 124, Milord, challenging the same. The petitioner filed the review petition.
There's no representation on behalf of petitioner. Call this matter week after next. Arun. Yes, Mr. Sadashivappa for respondent. ECR, SCR kept below. What matter, sir?
My lord,
What is this matter?
138 proceedings.
So LRs, you have come on record for LRs.
Last time,
Shall I admit it and list it for hearing?
please.
Admit. List for hearing. Public. Have they deposited any amount, Mr.
There is no reference here, my lord. I don't know.
Huh?
I don't know.
Nimsha.
I'm for the respondent in this matter.
Yavrali.
In 44.
One nimsha.
Five lakhs is the amount, my lord. Check amount.
Yes, to
5 lakhs.
50% order agide 22 ಅಲ್ಲಿ. You can withdraw that amount.
Please.
You are appearing in Mr. Sadashivappa's case.
Yes, my lord.
Arun.
Yes, my lord.
Yes, we'll permit him to withdraw the amount.
Yes, my lord.
Relax. Have some water there. ನಿಮಗೋಸ್ಕರನೇ ಇಟ್ಟಿರೋದು.
Thanks, my lord.
Take. ಅಲ್ಲಿ ನೀರಿದೆ ನೋಡ್ರಿ.
ನೀರ್ ಇಟ್ಟಿದ್ದಾರೆ.
Steps ಹತ್ಕೊಂಡ್ಬಂದೆ ಸಡನ್ ಆಗಿ ಕೊಡಿ.
Sit down. You have not made application.
No,
Take
I
the
don't.
oral request of you.
Yes, oral request.
Neer tago. Have some water, my friend. Already the complainant has died. LR's on record. At least let them enjoy this. In case he succeeds, you return him.
Yes.
All right. Learned counsel for the petitioner is present along learned counsel for respondent. Learned counsel Sri R.B. Sadashivappa on behalf of respondent makes an oral request to permit him to withdraw the amount deposited by the petitioner. Before the trial court. Contending that the check issued is of the year 2015 in favor of the original complainant who has now passed away. And the LRs are prosecuting this petition. Learned counsel for the petitioner fairly submits he would not have objection in withdrawal if the same is subjected to outcome of this petition. Accordingly, I pass the following order. The respondent complainant is permitted to withdraw the amount deposited by the petitioner. The trial court is directed to release the amount in favor of respondent complainant by way of electronic transfer upon the respondent furnishing relevant bank details on proper identification. It is made clear, in case the petitioner succeeds in the matter, respondent shall refund the amount along with prevalent bank rate interest. Full stop. The registry shall send back the trial court records to the jurisdictional trial court for compliance and secure the same immediately thereafter.
Great, great. Much of the. For the respondent.
Yes,
Today itself, we have discussed for settlement. Kindly have it on Monday. We will file joint.
Matadidira? Monday?
Monday.
All right. Learned counsel for both parties.
Petitioner present here, sir.
Huh?
Petitioner present here.
Along with the petitioner are present and submit that they have amicably resolved their dispute and settled the matter. They intend to file an application to compound the offense. Means call this matter on. Application, Aki, both of them to be present.
Yeah, please. In fact, the respondent is also present. We have discussed. We will file.
All.
Please.
Manjunath. Await records. Venkatachalapati. No representation on either side. Call this matter on 30th.
One appearing for the petitioner in this matter. Proceedings arising out of 138 proceedings.
Admitted.
Admit hearing.
Huh?
Hearing.
No, it is still for admission.
Admit hearing.
Hearing. Admit. List for hearing. Both learned counsels are present.
My lord, one submission. I'm not aware whether it is possible because he files two cases against the petitioner. One resulted in acquittal and one resulted in conviction. The matter which is acquitted, he has preferred one criminal appeal. My lord, whether it is possible, my lord, whether it can be heard together because of the roster, my lord, I'm not aware because once it is confronted that repayment has been made in this particular case, he misuses another security check and files another complaint, which resulted in acquittal, against which they have preferred one criminal appeal before this honorable court. So, my lord, if the law permits, it can be heard together.
And counter cases.
No, not case and counter case.
Complainant is one.
One, accused is
Two
same.
cases are filed.
Two cases are filed.
Against the
In
same
first,
accused.
yes, in first case, my lord, during the course of cross-examination, repayment has been confronted to the complainant. After confrontation, he set up another case which resulted in acquittal. That is the subject matter of criminal appeal which is pending before this honorable court. Now, if my lord, if your lordships could kindly direct that criminal appeal to be tagged along, so that my lord, it will be a clarity, because how a check has been misused and
Different transaction, different checks.
that will.
Different transaction, different. check.
Different transaction.
This is what I have been.
You'll have to prove that it is same transaction, one transaction, two different checks.
That
So in.
material is
in-
there.
In revision, it would be difficult.
That is true. But
Probably in appeal, it can be agitated.
irony is, my lord, it is the very same judge before the trial court passes two different orders in respect of the very same parties, in respect of the very same transactions.
But two
One
different-
resulted in acquittal and one resulted in conviction.
We don't know, I have to.
Please,
hear-
I'll.
So
please,
you will have to agitate it before the appellate court,
Please.
where the scope is large and wide.
Well, only we have succeeded. Now
No.
he has to prove that, my lord, because that resulted in acquittal against which he preferred criminal appeal.
So that you can bring it to the notice of this court when you argue.
Please, please. God bless you.
Yes, next.
On date and.
Huh?
Obliged.
Just by me, so 138.
Hmm.
Payment is already admitted and post the matter for hearing. In the meanwhile, I am permitted to withdraw the amount which has been deposited by the respondent. File any application? IA is I made request before this. No, it is not.
Yes, Akram. What's your?
File any application? They're orally they submit.
I will take his oral submission as an application. And permit him.
Please. Our condition.
You have deposited?
Yeah. The condition is always there.
With conditions, I will impose.
My request. Please. My objection may be noted.
Yes,
When I have been succeeded here, they have to return back to me.
yes,
That is there in the section, please.
yes.
Sir, I have a good case herein, that's why.
Learned counsel for the petitioner and respondent are present. Learned counsel for the respondent makes a oral request that he be permitted. Hina, Sheena, here,
He. None
that he be
she.
permitted, permitted to withdraw the amount deposited by the petitioner. Per contra, learned counsel for the petitioner objects to the same on the ground that he has a very good case on merits and he would succeed in the matter. And if the amount is permitted to be withdrawn, it would become difficult to recover the amount from respondent. Submission is placed on record. Full stop. What is the date of the check?
Date of the check is 2006.
Being heard, learned counsel for both parties, considering the fact that the check has been issued
Two checks, 2006.
in the year 2006.
Great. Exhibit P1 and P2.
Checks have been issued in the year 2006. A case having been filed in the year 2007. This court, it is appropriate for this court to accept the oral request made by the respondent by imposing certain conditions accordingly. Respondent, complainant is permitted to withdraw the amount deposited by the petitioner. Trial court shall release the amount in favor of respondent complainant by way of electronic transfer on producing relevant bank details upon proper identification. However, this order would be subject to outcome of this petition. In case the petitioner succeeds in the matter, respondent shall refund the amount to the petitioner with along with prevalent bank rate interest. Registry to send back the trial court records for compliance and secure the same after dispersing the amount.
Matter has to be admitted.
Admit, secure,
Please.
admit. Post for hearing, list for hearing.
This case, I prefer respondent, my lord, 138 matter.
Yes, Mr. Dharampa.
Last time, he has agreed that he will
Settlement.
set the matter.
50% amount is already deposited.
Withdrawn.
No, that is not
Earlier that
withdrawn.
was
It is, they
permitted
have
to-
deposited before the sessions court. and that amount was not transferred to trial court. Now, last time he has agreed for settlement and he will pay 1,50,000 today. And he has not entered into witness
Agreed
loss.
last time. Agree ಮಾಡ್ಕೊಂಡ್ರ last time.
Agree ಮಾಡ್ಕೊಂಡಾಗ.
ಹೇಳ್ತೀನಿ ಪಾರ್ಟಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದೆ. ಇನ್ಫಾರ್ಮ್ ದಿ ಪಾರ್ಟೀಸ್ ಆಲ್ಸೋ ಪ್ರೆಸೆಂಟ್. ಅದು ಬೋತ್ ಆರ್ ಸೇಮ್ ವಿಲೇಜ್.
ಅಲ್ಲ ಇರ್ಲಿ.
ಅವ್ರ ಪಾರ್ಟಿ ಎಲ್ಲಿ ಅವ್ರ ಕೈ ಸಿಕ್ಕಿಲ್ಲ ಅಂತ.
ಕೈ ಸಿಕ್ಕಿಲ್ಲ, ಅವ್ರಿಗೆ ಪ್ಯಾರಲಿಸ್ ಅಟ್ಯಾಕ್ ಆಗಿ ಮನೆಯಲ್ಲಿ ಇದ್ದಾನೆ. ಈಸ್ ಇನ್ ಹಾಸ್ಪಿಟಲ್. ಪ್ಯಾರಲಿಸ್ ಅಟ್ಯಾಕ್ ಆಗಿ he is unable to move.
ಯಾರು?
Respondent complainant.
Complainant.
Same village.
So amount is 3 lakhs.
3 lakh.
So 1.5 lakh is paid.
50%
Deposited.
50% already deposit. Permission ಕೊಟ್ಟಿದ್ದೀರಿ ಸ್ವಾಮಿ.
Are you disputing the check?
No.
Disputes, but.
ಅಲ್ಲ dispute ಅಲ್ಲ. ಚೆಕ್ ಅನ್ನ they admit the check, they admit signature, everything. ಅವ್ರು ಹೇಳ್ತಾರೆ ನಂಜುನ ಶೆಟ್ಟಿ, ನಾನು ಕೊಟ್ಟಿರೋದು ನಂಜುನನಿಗೆ. The bank account ನಂಜುಂಡ ಅಂತ.
But his name
That is only the defense ಅಷ್ಟೇ.
Records ಬಂದ್ಬಿಡಿ.
The year 2012, my lord. Even he has not entered into witness box. He has not led evidence.
So now whether there is settlement or not settlement.
Records ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ ನಾವು. ಈಗ ಯಾಕಂದ್ರೆ ಪಾರ್ಟಿ ವಾಸ್ ನಾಟ್ ಇನ್.
ಬರ್ಕೊಡಿ. Have you filed IE? Have you filed IE for withdrawal?
With that order.
ಹಾಕಿದ್ದೀರಾ?
ಅಲ್ಲ ಆರ್ಡರ್ ಇದೆ, ಅದನ್ನ ವಿಡ್ರಾ ಮಾಡಿದ ಆರ್ಡರ್ ಇದೆ.
ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
ಮಾಡಿಲ್ಲ.
ಅಂದ್ರೆ they have deposited the amount before the sessions court. Sessions court is dispose ಆಗಿದೆ. Now the honorable, your lordship has ordered to transfer the amount to trial court. That amount was not transferred. Sessions court ಚಾಮರಾಜನಗರ, trial court ಗುಂಡ್ಲುಪೇಟೆ.
It's only ordered for transfer. Where is it permitted for you to withdraw?
Yes, I will do
In
it. An
yes.
order copy ತಗೊಂಡಿದ್ದೆ, certificate copy the order.
Huh.
And I will submit before the trial court.
Question is,
As
where
per,
is
as per my knowledge, the amount was not transferred to trial court.
All right, I have already
Yes,
passed
yes,
an
yes,
order
yes.
for transferring from sessions court to trial court. Where is the order for you to withdraw the amount?
No, earlier, previous
ಆಗಿದೆಯಾ?
order.
What is the date? Court has to search. ಎಲ್ಲಾಗಿದ್ದది? ಧರಂಪಾಲ್.
7. 6/1/23, my lord.
Same shall be released. All right. Call this matter after 2 weeks.
Date may be fixed.
Whether the records are summoned or not summoned. Call this matter after 2 weeks. Admit, call this matter after 2 weeks. Admit the records ಕಳಿಸ್ತಾರ. Call after 2 weeks. You get the amount withdrawn.
Amount.
So that there's two orders are separate orders.
Yes,
You
yes,
take
separate.
certificate copy and get. Call after 2 weeks on date code.
This case I'm appearing for the respondent.
In
the memo. Already check amount will be paid.
Check amount.
Entire check amount will be paid in the trial court.
Paid.
Kindly record maybe trial court send it.
Entire check amount is deposited.
Deposited. But amount ತಗೊಂಡಿಲ್ಲ ಸ್ವಾಮಿ, ಸೆಷನ್ ಕೋರ್ಟ್ದು ತಗೊಂಡಿಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ತಗೊಂಡಿಲ್ಲ. ಲಾಸ್ಟ್ ಟೈಮ್ 2 months ಬ್ಯಾಕ್ ಜೆಸಿ ಇಲ್ಲಿಂದ ಆರ್ಡರ್ ತಗೊಂಡೋಗಿ ಜೆಸಿಗೆ ಅವ್ರನ್ನ ಅರೆಸ್ಟ್ ಮಾಡಿಸಿದಾದ್ಮೇಲೆ ಅವರು ಪೇಮೆಂಟ್ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ.
Sorry.
ಜೆಸಿಗೆ ಹೋಗಿ ಬಂದ್ಮೇಲೆ ಅವ್ರು ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ. ಅದು ಅಮೌಂಟ್
JC ಹೋಗಿ ಬಂದಿದ್ರಾ?
ಬೇಸಿಗೆ ಹೋಗಿ ಬಂದ್ಮೇಲೆ ಅಲ್ಲಿ ಪೇಮೆಂಟ್ ಮಾಡಿ
Petitioner.
ಪೆಟಿಷನ್
How many months?
ಒಂದು
He
2
has
days
completed the sentence?
2 days 2 days
2 days.
2 days ಅಷ್ಟೇ.
So entire amount of 5,25,000 is deposited.
ಡೆಪಾಸಿಟ್
That is the petitioner.
ಪೆಟಿಷನ್ ಅವರು 3 ಅಡ್ವೊಕೇಟ್ ಚೇಂಜ್ ಮಾಡೋ ಸಮಯ ಬರಲಿಲ್ಲ, ಅದಕ್ಕೆ ನಾನು
I list it on Monday. Then permit you to withdraw if it doesn't come.
ಲಾಸ್ಟ್ ಟೈಮ್ ನೋಟಿಸ್ ಆಗಿತ್ತು ಮೇಲೆ
ಅವ್ರಿಗೆ?
ನೋಟಿಸ್ ಆಗಿತ್ತು, ಇಂಟಿಮೇಷನ್ ಆಗಿದೆ, ಬಟ್ NOC ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಈಗ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಫೈಲ್ ಹೋಗೋದು ಅಷ್ಟೇ ಸರ್, ಏನಿಲ್ಲ.
Prakash Shetty. Barcode. There is no representation on behalf of petitioner. Learned counsel for respondent. What is your name?
HEG ಇವರನ್ನ ಗಂಗರಾಜ ರೆಡ್ಡಿ HE.
Gangaraja Reddy.
ಗಂಗರಾಜ ರೆಡ್ಡಿ HE.
ನಿಮ್ಮ ಹೆಸರಾ?
ನಮ್ಮ ಹೆಸರು ಸರ್.
Is present.
Petitioner, I am appearing for respondent, my lord.
Correct. On behalf of respondent is present before the court. He files a memo stating that the entire check amount has been deposited before the trial court, and he be permitted to withdraw the said amount.
Please, my lord.
It is seen that in the notings of the order sheet that there is continuous absence of the counsel for petitioner. And there is no representation either by the petitioner or the counsel. On the previous occasion, the counsel had retired from the case on behalf of petitioner. Thereafter, though NSC Vakalat is filed by Learned Counsel H.V. Ramachandra, there is no representation made on behalf of petitioner. We'll stop. When was the check issued?
Check, my lord.
You see, the check is of the year 2017.
17.
So also the
5 lakhs rupees check.
complaint filed is also of the year 2017. Under the circumstances, this court deems it appropriate to pass conditional order as under. The respondent complainant is permitted to withdraw the amount deposited before the trial court. Trial court shall release the amount in favor of respondent complainant. However, the same would be subject to outcome of this petition. In case the petitioner succeeds in the matter, respondent shall refund the amount in favor of petitioner along with prevalent bank rate interest. Registry to send back the trial court records to the jurisdictional trial court, to the magistrate court, the jurisdictional trial court.
Much obliged.
Lingaraju.
Gangaraja Reddy HE.
Prepare for petitioner, my lord. Last occasion, my lord, trial court records have been sent to trial court, my lord. comply the order of this court. Orders have been complied, my lord. Records is required to be called for.
Admit list for hearing.
Please, my lord, please.
Admit list for hearing.
Record on the trial court record on the.
It'll come anyway after that.
Lord, I am for the respondent, my lord. 2 days before, my lord, this matter was listed and I have undertaken a power, my lord. But the respondent is, my lord, out of station, my lord, as he went to the Haridwara. So my lord was pleased to post it on 1/10 of 2020, 1/10 of this year, my lord. But it is listed today.
Came early. Why?
It is to comply with 390C.
Yes, this matter, you are appearing for the respondent.
Respond, I have not filed any wakalat, my lord.
You are not filed.
I've undertaken that. I will file on
Well,
wakalat.
it doesn't matter. This is the offense under section 507.
Yes.
You have to comply with the order, comply with section 390. It's an acquittal order.
It's an acquittal order, my lord. Based on acquittal, they filed an appeal, my lord.
Then what happened?
In
What
appeal also, I have been acquitted. Now they have filed revision.
You are acquitted. Go and read section 390. He is in Haridwara. Let
He
him
went
pray
to-
well and come back.
Not like that,
Meanwhile,
my
you file. When is he coming?
on 30 or one, my lord.
Read section 390 CRPC.
My lord, even bare reading of it, my lord, it is only applicable in section 378. When appeal is filed under section 378, they have filed a revision, my lord. Whether it is applicable in the revision petition or I have to go on that, my lord.
We'll see. We'll consider.
Please, my lord.
Consider that. I'll call this matter on. When is he coming? First, after
No,
first.
first,
only.
any date of next month, my lord. Please.
I further respond.
Where is your friend?
Not approved.
The 138 matter?
Yes, my lord.
Admit and list for hearing?
My lord, permit me to withdraw that amount deposited by the
Who has moved the matter?
myself, my lord.
You moved the matter?
Yes.
For what?
So they are not they are not comply the order passed by this court regarding.
Then how I can permit you to withdraw when he has not deposited? Deposited ಮಾಡಿದ್ರೆ ನೀವೇನು withdraw ಮಾಡ?
That in appeal court, 20% they have deposited that amount.
There must be a conditional order.
Yes.
Are you sure he has not deposited?
Yes, my lord. I'll verify, my lord. Again, 1 week I need time. In the court below, I will go.
Learned counsel for the, there's no representation on behalf of petitioner. Counsel for respondent is present. Learned counsel for respondent submits that the petitioner has not complied the order dated 17/4/23 with regard to deposit of 50% of the fine amount. Full stop. In case the petitioner has not complied with the order dated 17/4 with regard to deposit of 50% of the fine amount, the respondent complainant would be at liberty to execute the order.
Yes. And if he's deposited, permit me to withdraw.
Huh?
If he has deposited, I'll withdraw. Yes.
You don't know whether he has deposited.
Yes.
You're not sure. You.
Yes.
Chikkanna, Lokesh. None appears. Call next week.
Okay, for petition.
What's the offense?
138 of an act.
Admits. Secure records, list for hearing.
Much.
Petitioner, Your Honor. Your Honor, this case, last year.
TCR was sent back.
Yeah.
TCR was sent back.
No, not yet received.
Have you withdrawn the amount?
No, nothing was done.
You have not deposited.
On the last occasion,
Bail also not taken, surety also not furnished.
on the last occasion, we had made the submission that the check that was in question, this is the 138 proceedings, the check that was in question was given by me to my supervisor, who has in turn given it to the complainant here, Your Honors. That particular supervisor is now in Japan.
Oh, this is the Japan case.
Your Honors, in fact, in this only one submission.
Right,
he-
you're making this one past 4 hearings.
Yes, Your Honors. He was scheduled to come by this week, but unfortunately, there has been some floods in Japan because of which the
What
flights have
happened
been.
in Japan?
In Japan, there have been some floods in Japan, Your Honors, because of which the flights have been restricted. So he has scheduled a ticket for the 10th of the October. He will be in Bangalore by 10th. So kindly give it on the first day after vacation itself. If on 10th he doesn't come and settle the matter with the respondent, then I assure that we'll comply with the order, Your Honors. That's the
Whom they are
submission.
mentioning is no way connected with this issue. I given a detailed statement of objection.
The complainant has, the petitioner has spoken with
The
the.
appellate court or before this court, grounds, nothing was mentioned about those things. In the cross examination also, no such a thing was happened.
One week time was granted from 12/9/24.
Yes.
If he does not, you are at liberty to execute. Won't execute it.
Dismiss this one.
Huh?
Criminal revision should be dismissed.
Dismissed. Call this matter after 2 weeks at the request of petitioner. I have already passed the order for you to execute.
Yes, I will.
Won't execute.
Let's shoot.
Yes, sir. Nanjareddy.
In this case, you last granted 4 weeks time to deposit the amount.
Madilla.
Madilla, because he was unwell. Monday or Tuesday. Still
Time is there or it is expired?
Time is there.
Is there?
So up to 26.
Ideal. Time is there.
Time is there. I will.
Deposit.
Monday or Tuesday.
I'll admit the matter and post it for hearing.
Yes, Miller, you will deposit within that time.
Admit, list for hearing. ಅದರಲ್ಲಿ conditional order ಇದೆಯೇನೋ?
Yes, yes. Within 4 weeks ಅಂತ ಇದೆ. We will see that it's deposited.
All right.
Bless.
Appearing by the petitioner.
Appearing for R1, 2 and 5, Miller.
The last day for
ನೀವೇ ಒಬ್ಬರ ಜಾಗ ಕೊಡ್ರಿ ಮೇಡಮ್ಗೆ.
sorry. I appear for R3, R4 and R6 matters. On the last date of hearing, my lords, the directed us to place on record the documents presented before the trial court, my lords, on the basis of which the impugned order was passed. We're placing those on record. My lords, may have this matter next week or after vacation. Senior counsel has been engaged in this.
Statement of objection, R7, who appears for R7?
I'm for R7.
You filed.
I filed on the last statement. Hello, statement of objection on behalf of R1, 2 and 5 is also.
Filed.
Yes.
So you are the complainant.
Please, my lords.
You have filed any civil suit also?
My lords, we had filed a protest petition before.
Apart
because
from
of-
this, have you filed any civil suit
No, my lords.
for recovery?
None, madam.
No, my lords.
Learned counsel, you are seeking time.
Please, my lords, the senior counsel has been engaged.
Counsel for the petitioner seeks time. Counsel for respondents are present along with learner at CGP. Call this matter after 2 weeks.
My lords, a date may be.
It will be.
Not okay.
Nagaraj Reddy,
Respondent, Your Honor. Kindly, it may be passed over, Your Honor.
Past,
Senior-
admit ಆದ್ರೆ ಆಯ್ತು. 138 proceedings.
again settled,
Yeah, no, not settling, milords. The order has been complied.
you have complied.
On the last occasion, milords, he has not
So for
engaged.
respondent,
Respondent, kindly, it may be passed over. My lord, senior is in next court hall. He'll be
for
back.
what purpose? Pass over for what?
He want to make some submission, my lord.
Submission, it is come up for admission. He has complied the order.
Admit ಆಗಿ ಆದ್ರೆ ಆಯ್ತು.
What is the amount you have deposited?
50% of the amount.
What is that amount? What is the check amount? You're not having the file.
Senior has it.
2,80,000 I deposited.
Kindly, it may be passed over.
5,60,000 is the fine amount, milords, out of which 2 lakh.
All right, pass over. Pass over, madam. Maybe he wants to make some submission. 5,60,000.
5,60,000 ನಲ್ಲಿ 50% deposit.
ಮಾಡಿದ್ದೀರಿ.
ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ.
Pass over.
Much obliged.
Some other milords, maybe I have some other day. ಇನ್ನೊಂದಿನ ಯಾವತ್ತು ಅಂತ.
Kindly, it may be taken on Monday, my lord.
Monday.
Yes, milords.
Request to call this matter on. Request of respondent, call this matter on. 23rd.
Much.
For the petitioner, my lord. My lord, my prayer is to remand this case back to the trial court because fair trial was not concluded, my lord. So, my lord, that prayer may be considered.
Where is your respondent party in person? Bharat Kumar. Oh, this is that advocate
Yes, my lord.
who was appearing party in person.
Yes, my lord.
What is the offense? 138.
Yes, my lord.
You have deposited?
Not yet, my lord. Time is still pending.
Huh?
Time is still pending and he is just released last week, my lord.
39.
Yes, my lord.
Right, since he is not here, I will have it next week, a week after next.
Yes, my lord.
Counsel for petitioner is present. There is no representation on by the party in person. Call this matter after 2 weeks. You are ready.
This case, my lord, the 138 proceeding challenged by the accused, my lord. The check amount is 2,05,000. The including the fine amount, the court has ordered for 3,25,000, madam. It is exorbitant and also the transactions are not took place between the parties. The notice is also not served on the accused, my lord. Yeah, they have already deposited 65,000 before the trial court.
Heard learned counsel for the petitioner. Issue notice to respondent. Orders on IA. 1 of 24. The order of sentence dated 26 August 23 in CC 195 of 18, passed by Senior Civil Judge JMFC at Somwarpet. Confirmed in Criminal Appeal 97 of 23, dated 8/7/24, passed by First Additional District and Sessions Judge Kodagu at Madikeri. Is hereby suspended Petitioner shall be enlarged on bail subject to following conditions. Petitioner shall deposit 50%.
Check amount is
Of
2,05,000.
Check amount,
Oh, 2,05,000, my lord.
inclusive of any amount already deposited. Within 4 weeks from today before the trial court. Stop. Next point, petitioner shall execute a personal bond for rupees 1 lakh with like sum surety to the satisfaction of trial court. It's made clear if the amount is not deposited as ordered here in above, respondent would be at liberty to execute the order.
50% check amount, my lord.
Check amount.
Please, my lord.
50% check amount,
Please.
inclusive of any amount you have already deposited.
Please, my lord.
Appellate court in the ಮಾಡಿದ್ರೆ
Oh.
ಅದನ್ನ minus ಮಾಡಿ.
Much obliged.
Yes, Shastri ji.
Lord, accused appeal, my lord, revision petition, my lord. 138 proceedings, there was a order of conviction confirmed by the appellate court, my lord. Check amount was 1,70,000. Lord, exhibit D, one was produced to show that, my lord, 75,000 was repaid, my lord, through checks. Exhibit D1, my lord, were
Heard.
produced.
The Red Council, same issue notice to respondent. Orders on IA number 1 of 24. Order of sentence dated 31/8/23 in CC 195 of 21 passed by JMFC Roman 5 Court Mangaluru DK confirmed in criminal appeal 243 of 23 dated 19/7/24 passed by First Additional District and Sessions Judge DK Mangaluru is hereby suspended. Petitioner shall be enlarged on bail subject to the following condition. Petitioner shall deposit 50% of the check amount, inclusive of any amount already deposited, within 4 weeks from today before the trial court. Petitioner shall execute personal bond for rupees 1 lakh with like sum surety to the satisfaction of trial court.
Please.
This matter is called out for the second time. The day at 12:37 PM, there is no representation. On behalf of petitioner. it is seen that the petitioner has been absent, counsel for petitioner has been absent continuously. It appears that petitioner is not interested in continuing to prosecute this case under the circumstances. Even today, when the matter is called out for the second time, there is no representation. Hence, it appears that the petitioner is not interested to continue the matter. Accordingly, the petition is dismissed for non-prosecution.
Yes. Make one submission. Last, in respect to D12, I'll make 2 minute submission.
You had already completed all your submissions.
D12 ಬಗ್ಗೆ ಒಂದ್ ಸ್ವಲ್ಪ how it is time bar debt ಅನ್ನೋದನ್ನ ಒಂದ್ ಸ್ವಲ್ಪ explain ಮಾಡ್ತೀನಿ sir.
With respect to D12,
P12,
D12,
please.
P12 or
P12,
P? That is that agreement,
ಹೌದು sir.
11/5/2005 or something.
ಅದ್ರಲ್ಲಿ 2 ತಿಂಗಳ ಒಳಗಡೆ ನಾನು ಪೂರ್ತಿ ಹಿಂದಿರುಗಿಸ್ತೀನಿ ಅಂತ ಹೇಳಿರ್ತೀನಿ. ಮೂರು ವರ್ಷ ಅಂದ್ರೆ 11/9/2008 ಆಗುತ್ತೆ. ಅಲ್ಲಿಗೆ 3 years ಎಕ್ಸ್ಪೈರ್ ಆಗುತ್ತೆ. 11/9/2008ಗೆ.
When is that dated? Exhibit D12, P12?
11/7/2005.
11/7/2005.
ಇದರಲ್ಲಿ ನಾನು ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ 2 ತಿಂಗಳ ಒಳಗಾಗಿ ಪಾವತಿಸಲು ಬದ್ಧನಾಗಿರುತ್ತೇನೆ ಅಂತ ಹೇಳ್ತೀನಿ. ಅದರಿಂದ 2 months ಎಕ್ಸ್ಟೆನ್ಷನ್ ತಗೊಂಡ್ರೆ 11/9/2008ಗೆ 3 years will complete. But I have issued as per them in the year 2010, 11/7/2010 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ. After lapse of 1 year, I have issued checks. Hence, in respect to time bar debt, if I am issued such checks under 138, not enforceable as my submission. And also the referred judgment of Supreme Court.
For that, first he has to accept it. He has to accept the dates so canvassed by you. He is not accepting that. Neither have you cross-examined to that extent.
Pass ಮಾಡಿದ್ದೀನಿ sir. ಹೌದು ಕೋರ್ಟ್ ಅದರಲ್ಲಿ. In
Have you-
respect to this is admitted fact. They are relying on this only.
No, they are relying that you were supposed to give the amount by 11/7/2005 extension made. All right?
No, there is no extension at all in respect to this document. There is no extension at all.
All right, but why did you, according to them, the check is given in 2010?
Please, in respect to, if at all, if it is given in the year 2010, if in respect to time bar debt, no checks will be issued, and also under 138, it is unenforceable as my statement.
Rest limitation will be start from the date of issuance of check, my lords.
ಹೌದು ಹೌದು ಅಲ್ಲ check in respect
Check is issued in the year 2010.
ಅಲ್ಲ in respect to time bar debt, if at all I am issued checks thereafter after lapse of 3 years, it is not enforceable is my submission as per the judgment submitted by them plus the Supreme Court's judgment they have submitted.
What is,
Yes, Bopanna's judgment.
that is that judgment?
Criminal appeal number 2743 of 2023.
Yes.
ಅದರಲ್ಲಿ paragraph 16. ಅದ್ರ ಮೊದಲನೇ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಪೀರಿಯಡ್ ಆಫ್ ಲಿಮಿಟೇಷನ್ ಬಗ್ಗೆ ಎಲ್ಲ ಹೇಳ್ತಾರೆ. ಇಂಕ್ ಪೇಜ್ 18.
Para 16.
ಪ್ಲೀಸ್
Yes,
ಅದ್ರ
18.
ಮೊದಲು ಪೀರಿಯಡ್ ಆಫ್ ದ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಪೀರಿಯಡ್ ಆಫ್ ಲಿಮಿಟೇಷನ್ 3 years ಅಂತ ಎಲ್ಲ ತೋರಿಸ್ತಾರೆ. ಪ್ಯಾರಾಗ್ರಾಫ್ 16 ನಾನು ಓದ್ತೀನಿ ಸರ್. The provision would indicate that in respect of promissory note payable at a fixed time, the period of limitation being 3 years would begin to run when the fixed time expires. ನಂದ್ರಲ್ಲಿ 2000
Promissory note.
ಇದು ಪ್ರಾಮಿಸರಿ ನೋಟ್ ಅಂತ ತಗೊಂಡ್ಬಿಟ್ರೆ.
So that is for
Limitation being 3 years would begin to run when the fixed time expires. Therefore, in the instant case, the time would begin to run from the month of December 2016. And the period of limitation would expire at the end of 3 years thereto, that is during December 19.
the pen, blue pen, pencil, very good. Can't you keep more pencils?
In that light, the check issued for rupees 10 lakh, which is subject matter herein is dated 28/4/2017. 2019 ಮೊದಲೇ ಕೊಟ್ಟಿರೋದ್ರಿಂದ that is enforceable ಅಂತ ಇದ್ರಲ್ಲಿ ಹೇಳ್ತಾರೆ ಸರ್.
Expired at the end of 3 years, it is in 2019. So here that B12 is issued in 2005.
Please.
So in 2008
it will expire.
It will expire.
But checks issued in the year 2010, after
Right.
lapse of 2 years.
The check is issued in 2017 here.
Here, my lords.
ಇದರಲ್ಲಿ 19 ಎಕ್ಸ್ಪೈರ್ ಆಗ್ತಾ ಇತ್ತು ಪೀರಿಯಡ್.
All right.
But 17 ಅಲ್ಲಿ ಚೆಕ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರು, ಅದರಿಂದ it will covers that limitation, it is well within the period of limitation, hence it is enforceable ಅಂತ ಇದ್ರಲ್ಲಿ ಹೇಳ್ತಾರೆ.
In the present case also, my check is issued in the year 2010, my lords. So it will expire in the year 2013.
ಆಗಲ್ಲ.
3 years.
ಆಗಲ್ಲ.
Talking about the agreement which you have produced, exhibit B12. Filed in the court in the Chief Metropolitan Magistrate on 2017.
ನಾನೇನಾದ್ರೂ ಚೆಕ್ 11/9/2008 ಒಳಗಡೆ ಏನಾದ್ರೂ ಚೆಕ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ದಟ್ ಈಸ್ ಎನ್ಫೋರ್ಸಿಬಲ್. ಇದ್ರಲ್ಲಿ ಪಾಸ್ ಆಗಿಬಿಟ್ಟಿರುತ್ತೆ ಸರ್ ಆನ್ ದ ಬೇಸ್ ಆಫ್ ಟೈಮ್ ಬಾರ್ ಡೆಟ್ ಅಂತ. ದೇರ್ ಆಫ್ಟರ್ ಕಮಿಂಗ್ ಟು ನೋ ದಟ್ ಇಟ್ ಈಸ್ ವೆಲ್ ವಿತ್ ಇನ್ ದಿ ಪೀರಿಯಡ್, ದ ಕೋರ್ಟ್ ರಿಮ್ಯಾಂಡ್ಸ್ ಬ್ಯಾಕ್ ಟು ದಿ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಟು ಎಕ್ಸ್ಪಡೈಟ್ ದಿ ಟ್ರಯಲ್.
Why was it sent, remanded?
Because it is well within the time. It has actually passed in the earliest occasion by the Honorable High Court.
Oh.
Thereafter, they appealed to the Supreme Court. When court finds that it is well within the period of limitation, as it is issued within the period of 3 years, hence it is enforceable. Hence, they have remanded it back to the trial court.
So what was the order of the trial court and the appellate court?
In my case, my lord,
In this case?
in this case, they have reversed it.
In this case,
In the citation relied by him?
Please,
The citation relied by him which you are reading,
please.
the complainant's case was rejected initially or convicted?
normally summons was issued.
In the
Accordingly,
earliest occasion,
482
482 file ಮಾಡಿ.
file ಮಾಡಿ.
Well, 482.
Yes, my lord. High Court has quashed the,
High court quashed.
yes,
Please.
my lords.
Against which they appealed Supreme Court.
So
Appeal.
that high court, quashing of the high court is set aside.
Set aside.
ಇದರಲ್ಲಿ ಅದು ಅಲ್ಲದೆ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಕರೆಕ್ಟ್ ಪೀರಿಯಡ್ ಟ್ರಯಲ್ ಆಗಬೇಕು, ನಂತರ ಓನ್ಲಿ ದೇ
They
ವಿಲ್
remanded. Restored to the file for considering.
without there being any trial,
All right.
they could not find that it is time barred or not ಅನ್ನೋದ್ರ ಸಲುವಾಗಿ remand. And also as per the, on the face of complaint, it shows it is well within the time, hence they have remanded it back. But in my case, my lord, it is constant case in the year 2005.
Original. ಎಲ್ಲ ಕೊಡಿ. So the question is only whether
Please,
the check is issued in pursuance to the exhibit P12.
please.
That
If
is your
he is
case.
claiming,
That is your case. The
Yes,
check
my lord.
is issued
complaint
Check
is
is
so much.
issued
pursuant to P12.
pursuant to, he has taken hand loan.
Read
For
your-
that hand loan,
Read your complaint.
please, my lord.
Something to notice ಅಲ್ಲ ಹೋಗಿ.
Chief, my lords. My chief examination.
Read the complaint.
Like second para of the complaint minutes. PCR.
It's your clear case that the hand loan borrowed from you is the year 2005,
5.
for which he issued the check in 2010.
Yes, my lord. For that hand loan, he has issued check in the year 2010. As my lords, he is my cousin brother. Though after several requests, no payment was done, my lords. For that, in the year 2010, he has issued checks. So From that date, my lords, after issuance of check, fresh limitation will be start.
But the judgment relied by you speaks otherwise.
Yes, my lord, it depends on. I have produced another case law, my lords, passed by the division bench of Kerala High Court, my lords.
Which High Court?
Kerala, my lords. Division.
No, you relied on the Supreme Court judgment.
Yes,
Which para did
Supreme
you-
Court, Supreme Court is saying, my lords,
which paragraph did you rely?
my lords. My lords, para number 8, my lords.
Yes, read it.
Yes, my lords. There is another case also has been discussed, my lords, from last, fourth line from last, my lords. Yes, Natarajan versus Samad Dharman. The High Court referred to section 25, clause 3 of the Contract Act, 1872, on which reliance was placed by the complainant, and observed that with regard to payment of time-barred debt, there must be a distinct promise to pay either whole or in part the debt. That the promise must be in writing, either signed by the person concerned or by his duly appointed agent. The High Court then observed that unless a specific direction in the form of novation is created with regard to payment of the time-barred debt, section 25, clause 3 of the Contract Act cannot be invoked. The High Court then went into question whether issuance of check itself is a promise to pay time-barred debt, and referred to section 4 and 6 of the NI Act. After referring to certain judgments on the question of legally enforceable debt, the High Court stated that for the purpose of invoking section 138 read with section 142 of the NI Act, the check in question must be issued in respect of legally enforceable debt or other liability. The High Court then observed that since at the time of issuance of check, that is on 1/2/2011, the alleged debt of the accused had become time barred, the proceedings deserves to be quashed. In our opinion, the High Court erred in quashing the complaint on the ground that the debt or liability was barred by limitation, and therefore there was no legally enforceable debt or liability against the accused. The case before the High Court was not of a such nature which could have persuaded the High Court to draw such a definite conclusion at this stage. Whether the debt was time barred or not can be decided only after the evidence is adduced, it being a mixed question of law and fact. Another case law is also discussed, Malus, A.V. Murthy versus B.S. Nagabasavanna. As the complaint has been rejected at the threshold, we do not propose to express any opinion on this question, as the matter is yet to be agitated by the parties. But we are of the view that the learned sessions judge and the learned single judge of the High Court were clearly in error in quashing the complaint proceedings. Under section 118 of the Act, there is a presumption that until the contrary is proved, every negotiable instrument was drawn for consideration. Even under section 139 of the Act, it is specifically stated that it shall be presumed, unless the contrary is proved, that the holder of a check received the check of the nature referred to in section 138 for discharge in whole or in part of any debt or other liability. It is also pertinent to note that under subsection 3 of section 25 of the Indian Contract Act 1872, a promise made in writing and signed by the person to be charged therewith or by his agent generally or specifically authorized in that behalf to pay wholly or in part a debt of which the creditor might have enforced payment, but for the law for limitation of suits is a valid contract. Moreover, the instant case, the appellant has submitted before us that the respondent in this balance sheet prepared for every year subsequent to the loan advanced by the appellant had shown the amount as deposits from friends. A copy of the balance sheet as on 31/3/1997 is also produced before us. If the amount borrowed by the respondent is shown in the balance sheet, it may amount to acknowledgement, and the creditor might have a fresh period of limitation from the date on which the acknowledgement was made. However, we did not express any final opinion on all this aspect, as these are matters to be agitated before the magistrate by way of defense of the respondent. This is a not case where the check was drawn in respect of a debt or liability which was completely barred from being enforced under law. If, for example, the check was drawn in respect of a debt or liability payable under a wagering contract, it could have been said that debt or liability is not legally enforceable as it is a claim which is prohibited under law. This case is not a case of that type, but we are certain that at this stage of the proceeding to say that the check drawn by the respondent was in respect of a debt or liability which was not legally enforceable was clearly from a perusal para number 10, my lords. From a perusal of the legal position enunciated, it is crystal clear that this court, keeping in perspective the nature of the proceedings arising under the NI Act, and also keeping in view that the check itself is a promise to pay even if the debt is barred by time, has in that circumstances kept in view the provision contained in section 25 clause 3 of the Contract Act, and has indicated that if the question as to whether the debt or liability being barred by limitation was an issue to be considered in such proceeding, the same is to be decided based on the evidence to be adduced by the parties, since the question of limitation is a mixed question of law and fact. Now, my lords, coming to para number 12, my lords. In para number 10, my lord, rest of the thing is the facts of the case which was included in that case, my lord.
Let's, in all the, please.
Complete, yes.
Para number 12, my lords. Having referred to the judgment cited prima facie, we are of the opinion that the decision in S. Natarajan and A.V. Murthy has taken into consideration all aspects. No other elaboration is required, even if the observations contained in the case of expeditious trial of cases under section 138 of NI Act is taken note, since whether the debt in question is a legally enforceable debt or other liability would arise on the facts and circumstances of each case. And in that light, the question as to whether the power under section 482 CRPC is to be exercised or not will also arise in the facts of such case. Even other, we do not see the need to treat that part to undertake an academic exercise on that aspect of the matter, since from the very facts involved in the case on hand, expressly it indicates that the claim which was made in the complaint before the trial court based on the check which was dishonored cannot be constituted as time barred, and as such it cannot be classified as debt which was not legally enforceable, which was not legally recoverable, the details of which we would advert to here below. In that way, we have chosen not to refer to the cases provided as a compilation, as it would be unnecessary to refer to the same. Here it is discussed, my lords. It has to be decided on the basis of evidence. Rest of the rest paras are, my lords, the evidence which we have, which is given in that case, it is discussed, my lords. So my only submission is, my lords, check is issued in the year 2010. From there, my lords, fresh limitation will be started, as discussed in para number 10, my lords. I can also produce, my lords, another judgment of single bench judgment of Punjab and Haryana High Court, my lords.
Within, may I make submission?
If the check is paid in the year 2005, then it is time barred, my lord. Check is paid in the year 2010. From there, fresh limitation will be start. If according to them, debt is barred by time, why the check is issued in the year 2010, my lords? And according to them, they have paid me the amount in the part amount in the year 2007 and 2010.
You are not accepting that.
Yes, in your case,
Yes, my
you
lord.
said they has made part payment.
According to them, they have made part payment, my
Ah,
lords.
they have made part payment of rupees 50,000.
50,000 in the year 2010, my lords.
That is exhibit D1.
Even is complaint. They have not accepted this one. my lord.
D1 is the police complaint filed by them, my lords.
No, which is the part payment according to you made?
I have not received any part payment, my lords.
No, you said that they made.
No, according to them,
It is their case.
it is their case.
May I make submission?
So it is not your case that they have made part payment.
They have not made part
At all.
payment, my lords.
Part payment. my
Your
lord?
case is,
Check is issued in the year 2010, my lords. For the debt which is received in the year 2005, my lords. Even my lords trial court.
so in between nothing is paid.
No, my lords. Even my lords trial court and first appellate also convicted them, not on the basis of exhibit P12. Exhibit P12 has not been considered by the trial court. It is a check, my lords. I can produce all the another case law, my lords, High Court of Punjab and Haryana, wherein it is a difference is given between section 18 of Limitation Act and section 25 clause 3 of Contract Act, my lords. At para number 10, my lords.
Para number?
10, my lords. Where section 18 of Limitation Act definition is given.
Yes.
Effect of acknowledgement in writing, where before the expiration of the prescribed period for a suit or application in respect of any property or right, an acknowledgement of liability in respect of such property or right has been made in writing signed by the party against whom such property or right is claimed, or by any person through whom he derives his title or liability, a fresh period of limitation shall be computed from the time when the acknowledgement was so signed, where the writing containing the acknowledgement is undated. Oral evidence may be given of the time when it was signed, but subject to the provisions of the Indian Evidence Act 1872. Oral evidence of its contents shall not be received. Explanation. For the purposes of this section, an acknowledgement may be sufficient, though it omits to specify the exact nature of the property or right, or averts that the time for payment, delivery, performance, or enjoyment has not yet come, or in accompanied by a refusal to pay, deliver, perform, or permit to enjoy, or is coupled with a claim to set off, or is addressed to a person other than a person entitled to the property or right. The word signed means signed either personally or by an agent duly authorized in this behalf. An application for the execution of a decree or order shall not be deemed to be an application in respect of any property or rights. Para number 12, my lords, where section 25 of Indian Contract explanation is given. Agreement without consideration void unless it is in writing and registered, or is a promise to compensate for something done, or is a promise to pay a debt barred by limitation law. An agreement made without consideration is void unless it is expressed in writing and registered under the law for the time being in force for the registration of documents, and is made on account of natural love and affection between parties standing in a near relation to each other, or unless it is a promise to compensate wholly or in part a person who has already voluntarily done something for the promisor, or something which the promisor was legally compellable to do, or unless clause 3, it is a promise made in writing and signed by the person to be charged therewith, or by his agent generally or specifically authorized in that behalf, to wholly or in part a debt of which the creditor might have enforced payment, but for the law for the limitation of suits. In any of these cases, such an agreement is a contract. Explanation 1. Nothing in this section shall affect the validity as between the donor and donee of any gift actually made. An agreement, explanation 2, an agreement to which the consent of the promisor is freely given is not void merely because the consideration is inadequate, but the inadequacy of the consideration may be taken into account by the court in determining the question whether the consent of the promissory was freely given. Difference, my lords. Section 18, effect of acknowledgement in writing. Where before the expiration of the prescribed period for a suit or application in respect of any property or right, an acknowledgement of liability in respect of such property or right has been made in writing, signed by the party against whom such property or right is claimed, or by any person through whom he derives his title or liability, a fresh period of limitation shall be computed from the time when the acknowledgement was so signed. Section 25 of Agreement Contract Act, my lords. Agreement without consideration void unless it is in writing and registered, or is a promise to compensate for something done, or is a promise to pay a debt barred by limitation law. An agreement made without consideration is void unless clause 3, my lords. It is a promise made in writing and signed by the person to be charged therewith, or by his agent generally or specifically authorized in that behalf, to pay wholly or in part a debt of which the creditor might have enforced payment, but for the law for the limitation of suits. In any of these cases, such an agreement is a contract. Para number 14, my lords. The distinction that can be discerned between an acknowledgement and under Section 18 of Limitation Act 1963 and a promise within the meaning of Section 25 Clause 3 of the Contract Act is of great significance. While both have the effect of creating a fresh starting point of limitation, an acknowledgement under the Limitation Act in order extend limitation must be made before expiry of period of limitation, whereas a promise under Section 25 Clause 3 of the Contract Act to pay a debt even though barred by limitation would renew limitation. Para 15, my lords. In any case, both the said provisions highlight that a right of lender to receive payment and an obligation of borrower to repay never dies with lapse of time, but it is the remedy which dies. But under certain circumstances, such remedy may get a fresh lease of life. Section 25 Clause 3 of Indian Contract resuscitates a time-barred remedy to enforce payment by way of suit consequent upon a promise made by debtor to pay off the debt or liability. In such a case where the payment could be enforced by a suit, it means that it still has the character of legally enforceable debt as contemplated by explanation to Section 138 of the Act. The judgment, my lords, KK Ramakrishnan versus KK Parthas, I have also given that judgment also, my lords. In that case also, my lords, the primary question that arises for consideration is, does the delivery of a check in favor of a drawee not create a legally enforceable liability? For the purpose of the present case, it does not appear to be necessary to go into this matter in detail. It may, however, be mentioned that under Section 25 Clause 3, a promise can be made even in a case where the limitation for recovery of the amount has already expired. Such a promise has to be in writing. It can be in the form of a check. When a check is delivered to the payee, the person is entitled to present the check to the bank and seek payment. In such an event, if the check is dishonored, the liability under section 138 would arise. It would not be permissible for the accused to contend that the liability was not legally enforceable. Para 25, my lords, in view of the above, internal para, my lords, sorry. In view of the above, the question as posed at the outset is answered in the negative. It is held that when a person issues a check, he acknowledges his liability to pay. In the event of the check being dishonored on account of insufficiency of funds, he will not be entitled to claim that the debt had become barred by limitation and that the liability was not thus legally enforceable. He would be liable for penalty in case the charge is proved against him. Para 7, my lords. In a subsequent matter before Kerala High Court, my lords, in P.N. Gopinathan versus Sivadasan and another, the counsel representing the accused while expressing doubts as regards correctness of the view of the K.K. Ramakrishnan's view, my lords. The above case had submitted that the matter be referred to a larger bench. However, the said submission was turned down while observing as under. I shall, for the purpose of argument in this case, assume that the liability is time barred. I say so because no such specific plea is raised before the courts below. Even assuming it to be time barred, when the check is written and signed, there is a promise to pay the amount to the payee through the drawing of course. Such promise, even if the liability is barred, is a valid and enforceable under law in view of section 25 clause 3 of the Contract Act. Thereafter, when the delivery takes place, the drawal is completed. Such check drawn is issued for the discharge of a liability, which is promised under the check itself. That being so, I do not find any reason to refer the matter to a division bench for further consideration. The argument of the learned counsel for the petitioner that there must be another agreement other than the check in order to recount the promise in the check to be a valid agreement for the purpose of section 25 clause 3 cannot obviously be accepted. The promise made in the check is an enforceable agreement as is declared in section 25 clause 3 of the Contract Act. The check issued delivered for the discharge of the said promise bar liability is thus perfectly within the sweep of section 138. Para 18, my lords. This court in a recent case, Sultan Singh versus Tej Pratap, dealt with in detail an identical matter wherein the following issue were formulated for adjudication. Whether issuance of a check for repayment of a time-barred debt would amount to a written promise to the said debt within the meaning of section 25 clause 3 of the Indian Contract Act 1872. Second, in case answer to the first question is in favor of the person in whose favor the check has been issued, then would the said promise by itself create any legally enforceable debt as stated in section 138 of Negotiable Instrument Act 1881. Third clause, whether in the facts and circumstances of the present case, the present petition under section 482 CRPC 1973 would be maintainable. Fourth, whether in the present case, the petitioner has been able to prove as to what would be the straight point of the period of limitation so as to establish that the check was issued after the expiry of the period of limitation. Para 19, my lords. While referring to case law extensively, issue number 1 and 2 as reproduced above have been decided as under. Thus, after considering the relevant provisions as well as the judgments of various courts on issue number 1 and 2, this court conclusively holds that the issuance of a check in repayment of a time-barred debt amounts to a written promise to pay the said debt within the meaning of section 25 clause 3 of the Contract Act, and the said promise by itself would create a legally enforceable debt or liability as contemplated by section 138 of Negotiable Instrument Act. Now, my lords, coming to para number 21, my lord. Other two issues are, my lords, it is relating to quashing of the CC proceedings, my lords. Para number 21, my lords. While considering acknowledgement or promise, another important aspect would be as regards the quality and kind of evidence required to establish such acknowledgement or promise. Honorable Supreme Court in Shapur Freedom Mazda versus Durga Prasad Chamaria, while discussing acknowledgement of debt in terms of section 19 of Limitation Act, held that an admission as regards liability may be in any form and may be expressed or implied, and that acknowledgement requires to be construed liberally. While relying upon Shapur's case, Karnataka High Court in Adivelu versus Narayanachari held as under. But when the word promise defined in section 2 clause B besides section 9 of the Act are kept in mind with the decision of the Supreme Court in the case of Shapur Freedom Mazda, wherein it is held that an admission could be expressed or implied, promise covered by section 25 clause 3 of the Act need not be expressed. If the legislature had intended that such promise should be an express promise only, it would have indicated so, but the word express is not found in section 25 clause 3 of the Act. So it would not proper to read so and restrict the scope of section 25 clause 3 of the act to express promise only. In the above view, I do not agree with the view taken by the Delhi High Court in the case of Tulsi Ram and also the Madras High Court in the case of N.E. Itirajulu Naidu versus K.R. Chinna Krishnan Chettiar. Para number 23, my lord. And last but not the least, section 29 clause 1 of the Limitation Act specifically provides that nothing in the Limitation Act shall affect section 25 of the Contract Act. Section 29 of the Limitation Act is reproduced here in clause 29 savings clause 1. Nothing in this act shall affect section 25 of the Indian Contract Act 1872. Para number 9, my lords. In view of the judgment of this court in Sultan Singh's case, wherein the issue in hand has been dealt with directly, and also in the light of judgment of Division Bench of Kerala High Court in K.K. Ramakrishnan's case, coupled with Supreme Court judgment in Shapur Freedom Mazda's case, the judgments of Delhi High Court pressed into service on behalf of petitioner, that is Prajan Kumar Jain's case and Vijaya Polymer's case, do not hold any ground and are not being referred to in detail in order to maintain brevity. Para 26. Consequently, in light of ratio of judgments rendered in Sultan Singh's case, K.K. Ramakrishnan's case, and Shapur Freedom Mazda's case, the contention put forth on behalf of petitioner regarding debt being time barred and that dishonor of a check issued after more than 6 years of advancement of loan would not attract provisions of section 138 of the Act, having been issued qua a debt not enforceable by law, cannot be accepted. Rather, it can safely be held that as on 6/7/2018, when the check was issued by the petitioner for paying off the loan advanced on 14/12/2011, the same was issued in acknowledgement of a debt, and upon its dishonor would make the drawer liable to proceed against under section 138 of the Act. So according to my lords, check was issued in the year 2010. They cannot contend that at the time of issuance of check, the debt was time barred.
Sultan Singh's case, you have produced Sultan Singh's case?
No, my lords, I can produce my lords.
That is of what quorum of bench?
That is also in respect to 482 minutes, in which also they have
The quorum,
Pashi.
what is the quorum, bench strength? What is the bench strength? That is a
Yes, ma'am.
Supreme Court judgment.
Please, my lords, I
K.K. Ramakrishnan, Shapur, Freedom Mazda's case, all this, what is the bench strength?
no, my lords, Sultan's case, Singh case is my lords, Punjab and Haryana. Punjab and Haryana High
Of
Court.
them are by, no, that is coupled with Supreme Court judgment, Shapur,
Shapur.
Freedom Mazda. K.K. Ramakrishnan is Kerala High Court.
Yes, my lord, I have already division bench of Kerala High Court, my lords. That was also my reference was given to division bench. It was before single bench, my lords.
Cannot be accepted. This judgment is rendered by Delhi High Court.
No, Punjab and Haryana High Court, my lords.
For Gurvinder Singh Gill is a.
Yes, my lord.
single
Here
judge.
the accused has filed criminal revision
So
petition.
the
my lord.
judgment rendered by a single judge. So
Yes.
judgment rendered by
Yes, my lord.
single judge.
Yes, my lord.
How he is differing from the judgment of a division bench? How can he say it cannot be accepted? Ratio of the judgment in Sultan Singh's case, which is a judgment of the division bench. All right?
Please, my lord.
And the judgment of Kerala, which is a judgment of division bench.
Please, my lord.
and Supreme Court
Shapur Freedom Masters case.
being time barred debt cannot be accepted.
Which paramount?
Your read, para 26 A and read. The judgment which you have read of
Yes,
the
my-
Punjab and Haryana High Court,
Cannot be
The
accepted.
contention put forth on behalf of petitioner regarding debt being time barred and that dishonor of a check issued after more than 6 years of a advancement of loan would not attract provisions of section 138 of the act having been issued a quad debt not enforceable by law. That is a submission, my lords, made by the petitioner's submissions. They were not relying upon those cases. Here, in this case, my lords,
where is the judgment of all these three cases?
my lords, I
Where is
can
that
pro-
Shapur Freedom Mazda?
my lords, I can produce, my lords.
Without reading, how you are arguing?
No, my lords, I have.
You can't just argue just by one judgment of a single judge of a Punjab Haryana High Court. Where is that? What is
KK
the,
Ramakrishnan's case, I have produced, my lords.
what is the analogy drawn in the Shapur Freedom Mazda's case of Supreme Court? What is KK Ramakrishnan's? You have produced that?
Yes, my lords, I have produced, my
Where
lords.
is that? Let
Division
us
bench
read.
of Kerala High Court, my lords.
Where is that? Ramakrishnan versus Parthasarathi.
Yes, my lords.
What does that case say?
In this case, my reference was
Shapur
given
Freedom's
to
case is in the year of 1961 by Supreme Court.
Let it be. What is this?
from para number 10, my lords.
Limitation.
Lords, in Shapur Madjas case.
Yes, what does that other case say? That
Shapur Madjas case. there.
Shapur.
Lords, I'll read the head note in the.
This requires some further hearing. Because we can't rely on the judgment of the single judge of Punjab, Haryana, which has gone against the division bench judgment of 3 High Court, 2 High Courts and Supreme Court. We have to see what the Supreme Court says and the division bench says.
This is the 61st judgment, Lord Shapurs, Lord, in which
Does that say?
Lord, the mortgage relationship in that, Lord, in which Lord, after lapse of limitation, the mortgagee writes a letter. Hence, Lord, the limitation saves. That is the Lord's conjunction of
That
that.
is under section 18, it
Please,
revives.
Please, that's the crux in that, Lord. But
is it.
Lord, the Honorable Bopana's judgment, Lord, clearly shows that after lapse of 3 years, Lord, as per paragraph 16 of the judgment, Lord, it clearly shows that when, Lord, if at all I have issued the check, Lord, within the limitation, that, Lord, we can say, Lord, acknowledgement, Lord, it has been extended time again. But it is not so, Lord, it is actually issued in the year 2010, Lord, hence, Lord, it is time barred. It is not legally enforceable, is my submission.
Whether this judgment of this Punjab Haryana High Court has been challenged.
That needs to be.
Huh?
That needs to be checked.
My lords,
You have now relied upon this now, or you produced now?
yes,
Please,
my lords, not now I have produced.
Huh?
Now I have produced.
Check whether that has been taken up before the Supreme Court.
Yes, my lord, I have,
And place all that judgment.
please, my lord. Accordingly, my lords, in para number 10 of the Supreme Court case law which I have produced,
If my lord realize
It-
that Supreme Court judgment,
Supreme Court, my lords, which I have produced,
I'm a,
K Haimawati, para number 10.
Hmm.
There is also, it is clearly stated that a promise can be made under section 25 clause 3 in a form of check, my lords.
16 rules that.
16, say paragraph 16 is related to their evidence.
Hmm.
The evidence which is produced in that case, my lords. Here, the evidence has to seek. Even-
what? So it has to, you have to corroborate it further by your evidence.
Please,
My lord,
that is
I
what,
have
my lords,
given, I have,
when we approach
yes,
this
my lord.
under 482, my lords,
Please understand.
not, it is not,
Evidence
it
is
is mixed
placed, my
question
lords.
of law. Hence, it has to be
In
adduced
para
by
16
evidence.
In para 16, it goes again with regard to the limitation of 3 years.
That is pertaining to a acknowledgement, my lords. For acknowledgement, 3 years, my lord. Check is issued in the year 2010. So a fresh
Not your case that the transaction of 2005 is different from that of 2010 check. It is one and the same.
one and the same.
That
Please,
is
my-
why whether it will barred by time is the question that has to be considered by this
No,
court.
no, my lords, even if the acknowledgement is barred by time, my lord, sir, check is issued in the year 2010. A fresh limitation will be start to that loan.
That is negatived by the Supreme Court in para 16. Read para 16.
In every cases, my lords, the Supreme Court has discussed that it has to be depends upon evidence, my lords. I can produce another case, my lord.
Evidence was present.
That
in
is
the-
your evidence. You
Supreme-
don't have any evidence to show that after that P12,
Yes, my lord.
which is issued in 2005,
Five.
there was subsequent transaction or this is given in acknowledgement to that. There is nothing of your evidence. After 2005, check is given in 2010. That is all is your statement.
Yes, my lord.
How do you relate that to this?
Even though my lords, first appellate court and conviction, they have not considered exhibit P12. P12 and consider ಮಾಡ್ಲಿಲ್ಲ.
Yaro,
Trial court and first appellate court.
I will see in the.
Please, my lord.
My lordship, on serial number 93, I'm seeking adjournment 2 weeks, my lordship. We have applied some documents to rely, to address the argument.
Of Learned Counsel for petitioner,
Respondent, my lordship.
respondent, call after 2 weeks. Await records.
My lord, serial number 88. my
Obliged.
lords.
Serial number 90.
My lords, serial number 88, my lords. And for petitioner, my lords.
Hmm.
Pray for short accommodation, my lords.
At request of petitioner, call this matter on 30th.
My lord, serial number 90, my lord. In this case, some negotiation talks are going on, my lord.
Huh? Negotiation. Who's for the respondent?
Preparing for the respondent.
Nadita idea. Learned Counsel for the petitioner and respondent submit that talks for settlement are midway. Hence call this matter after
8 may be fixed, after vacation.
on 30th.
Obliged.
After
After vacation.
After vacation.
14th October.
Obliged.
Today number 73.
Now I'm tendering 1 lakh rupees.
Huh?
Yes, 1 lakh I'm tendering today.
Ah.
The balance will be paid after 1 month, my lord.
Ah,
Yes, now I'm paying 1 lakh.
I'm appearing for respondent.
ready.
Ready.
Kodi,
What the?
And respondent also present before.
kodi.
Totally.
ಅದು ಎಲ್ಲಿಂದ ಬಂತು?
ಅದು ಅವ್ರ ಜೋಬಿಂದ ಬಂತು.
ಅದು ಜೋಬಿಂದ ಎಲ್ಲಿಂದ ಬಂತು?
ಊರಿಂದ ತಗೊಂಡ್ ಬಂದ್ರು.
So you want to legalize that by high court order of some amount from where he's got, how he got, God knows. Withdrawn from the bank or kept at home?
ಎಲ್ಲಿಂದ ತಗೊಂಡ್ಬಂದ್ರಿ? ಊರಿಂದ. ಬ್ಯಾಂಕಿಂದ ತಗೊಂಡ್ಬಂದ್ರು. ಎಲ್ಲಿಂದ? ಬ್ಯಾಂಕ್.
ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ವಿಡ್ರಾ ಮಾಡಿದ್ರಾ?
ಬ್ಯಾಂಕಲ್ಲಿ ವಿಡ್ರಾ ಮಾಡಿದ್ರಾ? ATM ಅದೇ ATM ಬ್ಯಾಂಕಿಂದ
ATM.
ಎಲ್ಲಿ ಬೇಲೂರಿಂದ?
Learned counsel for the petitioner accused submits that the petitioner who's physically present before the court is has tendered a sum of
Tendered.
rupees 1 lakh by way of cash
Yes.
to the respondent who is physically present before the
Yes.
court in the presence of his counsel and identified by his counsel. What is the balance amount?
Another 1.5
When is,
after 1 month, my lord.
and full stop, learned counsel for the petitioner submits he is inclined to repay the balance amount if 4 weeks' time is granted.
Please.
Hence call this matter after 4 weeks.
Madam, end of October.
Huh?
End of October or November first week, my lord.
October,
November first week.
8 October,
28, 28.
28.
ಆಗ್ಬೋದು.
Sign marks. Receipt or amount.
Others.
ನಿಮ್ದು ಮೆಟೀರಿಯಲ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಬಂತಾ?
ಇನ್ನು ಅದು ಬರ್ಬೇಕಿತ್ತು, ಅದರಲ್ಲೇ ಶಾರ್ಟೇಜ್ ಮಾಡ ಅವ್ರು ಹೇಳಿ ಆಗ್ಲಿ ಸರ್, ನಾನು ನೋಡ್ತೀನಿ.
Madam.
ಆರ್ಡರ್ ಶೀಟ್ ಸೈನ್.
Madam, ಈ ಲಾಸ್ಟ್ ಇದರಲ್ಲಿ ಇದು ಮಾಡಿ. ಡೇಟ್ ಆಗ್ಬೋದು. ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದ್ರೆ ಸೈನ್ ಮಾಡಿಸ್ಕೊಡ್ತೀನಿ ನಾನು.
ಏನು ಬೇರೆ ಬೇರೆ ಬಂದಿದೆ ಇಲ್ಲಿ 16 ಹಾಕಿ ಇಲ್ಲಿ ಅಲ್ಲ ಇಲ್ಲೇನು ಬೇರೆನೇ ಬರ್ತಾ ಇದೆ. ನೋಡಿ ಕರೆಕ್ಟ್ ಮಾಡಿ ಕೊಡೋ ಮಾಸ್ಟರ್.
ಸಹಕಾರ ಅವ್ರೆ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಆಫೀಸರ್ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ವಾ? ಗೊತ್ತಿಲ್ಲ.
ಮುದೋಳ್ ಸರ್ ಇನ್ನು ವೇಟಿಂಗ್ ಐತಾ?
ಹಾ ವಿಜಯ್ ಸರ್
ಸರ್ ವೇಟಿಂಗ್ ಐತಿ?
ಏನ್ ನಾವ್ ಇಲ್ಲಿ ಡಿಸ್ಪ್ಲೇ ಏನ್ ಬರ್ತಾ ಇಲ್ರಿ ಇಲ್ಲಿ.
ಇಲ್ಲ ನಾನು ಅದೇ ವೇಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಅವಾಗಿಂದ ಮತ್ತೆ
ಸರ್
ಡಿಸ್ಪ್ಲೇ ಬರ್ತಾ ಇಲ್ಲ.
ಬೆಂಚ್ ಇನ್ನು ಸ್ಟಾರ್ಟ್ ಆಗಿಲ್ಲ, ಸಾಹೇಬ್ರು ಡಿವಿಷನ್ ಬೆಂಚ್ಗೆ ಹೋಗಿದ್ದಾರೆ, ಬರ್ತಾರೆ.
ಓಕೆ ಓಕೆ ಓಕೆ.
ನೀವೇ ಮಾತಾಡ್ಬೇಡಿ, ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಓಕೆ.
Innೊಂದು you, Madhyana, we heard that matter. Give it.
Matter pertains to the Harvard bench. For admission, serial number 1, Shivraj P. Mudol.
Appear for the petitioner, my lord.
Yes.
I appear for
I appear for the contesting respondent.
Lord, Lord, may I make one submission?
Yes.
Lord,
Yes,
Lord,
Mr. Shivraj.
Lord, I'm praying not a short time for this region, Lord. Any date, 12th or 13th, 14th, huh? 13th or 14th, my lord. I letters are both.
It was specifically stated, my lord.
They have filed objection to this review petition, my lord. I have gone through it, but the question of law, my lord, is there. So I require some 2 days, my lord. I am not keeping well, therefore, my lord, I am not completely, my lord.
Your friend Saurabh Hegde is here.
Yes, he is here.
Lord, it was.
Oh, he is here in Bangalore, traveled
Yes,
from Harvard.
Yes, my lord. Let him, my lord, if my friend wants, my lord, let him address
Yes.
argument.
I will only argue one matter, my lord. Kindly permit me to argue on the second matter because
No.
I have only filed a statement of objections in that matter.
But both
That is completely different from the first matter. That's what. Now they want to take shelter under the first matter and they want to, claim under this also. That is not possible. Kindly take the second petition, my lord.
What is the difficulty? What is the difficulty as of now?
My lord?
What is the
There is
difficulty as of now faced by you? What is the difficulty that is faced by you pursuant to the order?
My lord, pursuant
What
to
happens
this
is-
order, my lord has granted, my lord, interim order in favor of the respondent herein, not to precipitate. Therefore, in another writ petition, he is having a benefit of interim order in other 2 writ petitions. Therefore,
not
as of
related
now,
to
my lord,
is-
there is no threat against him, my lord. 68 order, my lord, my lord, kindly recollect, 68 order, original
No,
order is.
that he wants time. He is not well.
I leave it to this honorable court.
See, I have to hear you anyway, both of you.
Please,
So he may be trying to say that one is connected with the other. According to you, 2 are different because one is a death case where the party.
Yes.
That is your
Exactly,
contention.
exactly.
I remember this.
Yes,
Yes,
exactly.
That is
same.
your contention.
And one more, just to add to this, and in that second writ petition, my lord has never said that there is an alternative remedy available to the petitioner. It is only said that because of the death, this proceedings cannot be. I have filed the statement of objection in only one petition.
All right, we'll take it up together because now piecemeal serves no purpose.
Yeah, that's all.
I just wanted to say both are different. If my lord.
That's understood.
Yes. But 12, 13 and 14th.
When do you want Mr. Shivraj?
Lord, Lord, 14th, Lord.
Lord, any Friday. 14th is not possible.
14th or 15th, Lord.
You want it on Friday?
Friday.
Please,
Have it
Lord.
on 25th.
Please, Lord.
25th October.
Please, Lord.
So that is only the next working day after the vacation. Otherwise, 27th anyway, so not. You want it in October?
Yes, Lord.
All right, we'll have it on 25th is okay.
Please.
Please, learned counsel for the petitioner. Both the matters seeks time. Learned counsel Sri Saurabh Hegde is physically present before this court. Counsel Sri Vijay M. Malali for R4 and R5 is present through video conferencing. At request of counsel for petitioner, list this matter on 25th October.
Please, much over.
You have come only for this matter?
Yes.
It
was last time my lord had clearly stated.
You should have told him that you will be taking time. You could have appeared from VC there only.
At least on 25th, I request my learned friend.
And we cannot contemplate what is going to happen, where he'll be, whether in India or in some other country. He's a busy man. So are you. Please. All right. Positively, 25th.
Please, much over.
For dictating orders, still number 68. Lovita Shravanker.
Correspondent.
So what you do is both of you get to know this. Because once the order is passed, if it runs contrary to the judgment of the apex court, then it will create more confusion. And prima facie for me, the single judge judgment of the Punjab Haryana High Court is not appearing to be in consonance with the
Supreme Court judgment.
judgment of the Supreme Court, though I have not dealt with that other matter, Supreme Court, which you are relying on that freedom.
And in all those matters, there are 482 matters, in which they when
No, whether it is 482 or whether it is 397,
In all.
whether law ratio has been laid down, law has been laid down, that is what has to be considered.
In all.
The fundamental in your case is whether it's a time bar, that's all.
and also the misuse of the checks which were given.
Misuse of the check, you can argue right now, I'll pass orders. That is a different issue.
Please.
Whether it is a time barred check taking into consideration exhibit P12 and is averment made in the complaint that the check is issued pursuant to the loan taken
in the year
and the
2000.
agreement of P12,
Please.
which is in 2005.
Yes.
It is not his case of the complainant that after 2005, any payment was made or any acknowledgement is given.
Correct.
To show, come within the category of Section 18 Limitation Act. But he contends that the very issuance of the check itself creates a fresh cause of action on 2010.
It is an acknowledgement
But the
for
judgment of the apex court justice,
Please.
Bopanna's judgment says, once 2005, after that 3 years, and after that it is time barred.
Correct.
That is what I understand.
Please.
We also go through it,
Please.
find out what are the other judgments of the Supreme Court,
Please.
place it, pass orders on that.
Before trial court also, my lords, no contention was taken regarding time bar. And accordingly, my lords, first appellate court and trial court has not considered exhibit P12. P12 is,
Whether trial court has taken, not taken,
already all
appellate
those
court has
documents on
taken,
record.
yes, my lord.
not taken, that will not have any bearing because he's now here challenging both the judgment.
Prima facie complaints also.
He's challenging that here.
Yes, my lord. My question, my lord, if the time is barred,
not a fact, it's
why
the-
the check is issued in the year 2010? That they has to prove that check is not issued in the year 2010, it is issued in the 2005. In all the cases, it is stated that, my lord, it has time barred date has to be decided on depending upon the evidence. To prove that no evidence has been given, my lords.
In my evidence, I have clearly stated, pursuant to the
My lords, coming part of the
2005,
defense
in
evidence.
respect to the 3 checks were issued, and also complaint prior to.
Anyway, get this legal point first sorted out.
My lords,
Then we'll go through the evidence, whether it is your say.
exhibit D1, they are relying upon police complaint, my lords.
In that, there is no
They
check
have
mentioned.
filed police complaint. But what happened to that police complaint? Whether police has taken any action or not? If police has not taken any action, whether they have made representative to any higher officer, whether they have given any representation to banker to stop the payment, nothing is there. So that cannot, just to take a defense that I have filed a complaint.
ಬಹಳ ಓಲ್ಡ್ 2005 ಕೊಟ್ಟಿದ್ದು ಪೂರ್ತಿ ನೆನಪಾರೋಗಿತ್ತಾಗಲಿ ಪೂರ್ತಿ ರಿಟೈರ್ಡ್ ಆಗಿ ಹೋಗಿದ್ದೆ ನಾನು ಊರ್ಗಲ್ಲಿ ಶಿಫ್ಟ್ ಆಗಿದ್ದೆ
That is again 10 days prior to the date of check.
ಹಾಗಿದ್ರೆ ನಮ್ ಚೆಕ್
According
ಪೂರ್ತಿ
to them, my lords, they have issued me 3 checks. If I want to cheat them, I have cheated them in all 3 checks, not only one.
ಅದ್ಯಾಕೋ ಹಾಕ್ಲಿಲ್ಲ ಅದು
Anyway,
ಅನ್ಕೊಂಡೆ
get this, the judgment.
Even them check ಮೇಲೆ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಕೂಡ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಲಿಲ್ಲ.
ನಂಬರ್ ನೆನಪಿರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ ಅದರಿಂದ
ಚೆಕ್
ಮೊದಲೇ
ಮೇಲೆ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಬರ್ತದೆ, ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಡೇಟ್ ರಿಟರ್ನ್
ಅದೆಲ್ಲ ನಂದು ಪೂರ್ತಿ ಡಿನೈ ಮಾಡಿದೆ ನಂದು ಪೂರ್ತಿ ಸಿಗ್ನೇಚರ್ ಅಷ್ಟೇ ನಂದು ಇನ್ನು ಪೂರ್ತಿ ಕಂಟೆಂಟ್ಸ್ ನಂದಲ್ಲ
ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್.
All right, get hold of this judgment first. Whatever you're relying, should place it before the court.
Please.
You're relying on the single judge, you're relying on Supreme Court judgment, the single judgment, and the division bench of Kerala relies on few other Supreme Court. That should be placed to see whether facts are matching. Only then the legal issues can be thrashed out.
My only case is my lord, check is issued in the year 2010.
Sir, you want to argue?
Yes, yes, my lord.
Then you produce and argue, I'm ready to hear you.
Yes, my lord, I'll produce.
Okay, argue now.
No, my lord, I'll produce.
Why you're
yes.
wasting time? Others, your brothers are sitting. You have not come fully prepared with all the judgments which you are relying. When you're relying, you should place that if I ask you, you don't have that.
I have another judgment, my lord. In this also, my lords, the Supreme Court has decided that based on the evidence, it has to be decided.
Can't tell you anything more. Workoli. Learned counsel for both parties. Rely further. Makes submissions. I intend to rely on the judgment of the apex court, seek sought accommodation, and list this matter. When will you do it? 27th?
26, 27, I'll not.
30th?
Yes, ma'am.
Call on 30th.
Bill number 69 adjourned. 70 further arguments.
Call number 4, my lord.
I am not ready with the judgment yet. Midway. So I'll give you some other date.
First.
List on 1st October.
First.
Heard further. Learned counsel K. N. Chandrasekhar Reddy. And what is your?
LM Ramaya, I'm appearing for LM Ramaya.
LM Ramaya Gowda for R4. Call on 1st October.
Bill number 71, Sri Ravindra B. Deshpande.
Petitioner, madam. In this case, argument, my side argument is over, my mention ಮಾಡಿದೆ, colleague ಮಾಡಿದ್ದಾರೆ. It is any short date may kindly ಬೇಕು. ಏನಾದ್ರು ಮುಂದುವರೆದಿದ್ರೆ next date ಅಲ್ಲಿ ಮಾಡ್ತೀನಿ.
ಯಾರು ಮಾಡ್ತಾರೆ?
ನಮ್ಮ colleague ಇದ್ದಾರೆ, ಅವರು ಮಾಡ್ತಾರೆ.
You are going to argue today? What is this offense?
Misappropriation by the secretary of the panchayat, my lord.
408, 409.
408 and 409 IPC, my lord.
Order sheet kodi. So you will have to reply to his arguments. Your colleague has to reply.
Please, madam.
Do it on the same day. Why post it another day?
Any other day, madam.
When is coming? Where is Ravindra? Who was argued?
Umesh, ನಮ್ಮ colleague Umesh. Yes, please, madam.
All right, we'll have it this matter on 27th.
Please, madam. Okay.
Huh?
Please, madam.
On the request of counsel for petitioner, call on 27th.
Please.
Final hearing, Bill number 72, Prakash R. Gans.
Lordship, for the petitioner, Lordship, I received certified copies yesterday, Your Lordship. And I need to go through the papers, Your Lordship.
What you received yesterday?
Certified copies. I filed NOC Wakalat in the month of June.
Ah.
Had applied for certified copies of entire petition, Your Lordship. I received it yesterday. Soon after vacation, it may be, Your Lordship.
What is the offense?
Offense is under 304A.
When did you come on record?
In the month of July, June, July.
How many advocates prior to you have come on record?
Lordship, in the month of in the year 2015, advocate has filed a revision petition, Your Lordship, and he passed away. After that, one girl by name Sangeeta has undertaken to file a wakalat, but she haven't filed wakalat, Your Lordship. The petitioner has been taken into custody. NBW was issued by the coordinate bench of this honorable court, Your Lordship. After that, I came into the picture, Your Lordship.
He was taken to custody.
Please, Lordship. I've paid rupees 50,000 as a fine amount, Your Lordship, for being delay in the case, Your Lordship, for making delay. Only after that I was released on bail, Your Lordship.
You have not paid 50, you have paid 50,000.
Please, Lordship, please. I've produced a DD, Your Lordship.
So 1 year for 304A. Learned counsel for petitioner seeks time on the ground that he has recently come on record, that is June 2024. He has not obtained certified copies of the case papers. Let's call this matter on 30th.
Lordship, after vacation, Your Lordship. After vacation, Your Lordship, kindly. Need some time.
30th.
Soon after vacation, Your Lordship, kindly, please.
30th on that day we'll see.
Please.
Kindly pray for time, my lord, because co-counsel has some medical issue. She went out, my lord. Kindly pray for time 1 week. It- Translated copy is ready, my lord. Produce.
Parted in again. Request of counsel for petitioner, call this matter on immediately after vacation. After vacation. If you're not interested in coming, what to do?
I appear for petitioner. Check amount is rupees 22,67,000.
8 cases.
Awesome. In all these 8 cases, the total check amount is 22,67,000.
You argued earlier.
Earlier I have argued. I have deposited 7,36,000.
All right, total amount is?
Total amount is 22,67,000. I have deposited 7,36,000. My learned friend has filed an application.
7 lakhs?
36,000. My friend has filed an application to withdraw the amount. I have no objection for that withdrawal. And talks were held about 2 days back in the office of the complainant. And I sought for some more time to.
You want some more time?
Some more time with the complainant for an amicable settlement. My friend was also there.
Andidru, they offered some below the check.
They are asking some enhanced amount apart from this.
ಏನ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ವಿ ಅದನ್ನ ತಗೊಳಿದ್ರು ಅದಕ್ಕೆ ಆಗೋದಿಲ್ಲ ಅಂತ.
So you want to settle or you want to argue the matter?
I am sincerely trying for a settlement.
All right, you do it by the next date.
No, because amount is heavy, your lordship may kindly grant 14th or 13th of next month.
In all these petitions, you have filed application?
Yes. It may be, amount may be released. I have no objection.
The amount is different in each of the petitions?
Yes, different.
What is the amount?
My lord, sir.
Record. Learned counsel for petitioner and counsel for respondent are present. Learned counsel for the petitioners filed. IA number 1 of 24. Counsel for respondent. Complainant. IA, is it different number in each of the case or IA?
Different numbers are there.
Why
There
instead
are-
of IA 1, you just say IA. for withdrawal of the
Yes,
amount.
same number.
So that is 30%, is it?
30%.
In all the cases you have deposited?
33% I have deposited
In
in
all the
all the cases. Total amount deposited by me amounts to.
You have not filed objections. You're willing.
I have not filed any objection.
You have no objection in him withdrawing.
No objection to withdraw the amount.
Learned counsel for the petitioner fairly submits that he would not have much objection in the respondent complainant withdrawing the amount, provided the same is subject to outcome of this petition. Under the circumstances, placing the submissions of learned counsel for petitioner, and on the basis of the content stated in the application for withdrawal of the amount, being satisfied with the reasons stated therein, this court deems it appropriate pass a favorable order on IA for withdrawal of the amount. Accordingly, following orders passed. Respondent complainant is permitted to withdraw the amount deposited by the petitioner accused in all these cases. The trial court shall release the amount so deposited in each of the cases to the respondent complainant by electronic transfer upon respondent furnishing relevant bank details on proper identification. However, the said order would be subject to outcome of this petition. In case the petitioner succeeds in this matter, in these petitions, respondent complainants would be liable to refund the amount along with prevalent bank rate interest. The registry shall transmit the records to the trial court. Transmit the trial court records to the trial court for compliance of this order and resend the same back to this court immediately after compliance. Call this matter on. On the matter, are you allowed?
Lordship has sought certain clarification with regard to section 3 of PO Act on last occasion. So far as whether the punishment is
Offensive.
offensive 465, 471, 468, 420.
Yes, I asked you this question.
The punishment imposed is less than 2 years, 1 year. Your Lordship has sought the clarification with regard to whether the punishment is the criteria or whether the punishment provided under the provision is the criteria. The punishment is the criteria.
It is not the offense.
Offense.
It is the punishment imposed by the.
Yes.
And
So
not
far as
the-
consideration of PO Act.
Not more than 2 years. Not more than 2 years. Punishment.
Punishment imposed by the.
Imposed is less than 2 years if it is.
Good. Found guilty of having committed.
Yes, ma'am. Yes, madam. See, now one matter, the accused was convicted for 325, wherein the benefit of PO Act has been extended by the Honorable Supreme Court. The punishment provided under provision is 7 years. And punishment imposed was 1 year. Therefore,
Section 3 was benefit was.
benefit is, can be extended. Sir. relevant paragraph begins from paragraph 2. May I read, my lord?
Yes.
The occurrence took place as a result of sudden quarrel between some children and others of the family of Hansa and MST Rao in regard to throwing of some bricks and brickbats. In the course of this sudden occurrence, Hansa is stated to have caused the injury on the head of MST Rao. Learned counsel for the appellant has pressed for our consideration the application of provision of section 4 of the Probation of Offenders Act 1958 to this case. We are inclined to accept this stand taken on behalf of the appellant as justified and tenable in law on the special facts of the case. The appellant was found guilty of having committed the offense of causing grievous hurt, punishable under section 325 of the Penal Code. The maximum sentences provided therein is 7 years. And having regard to the circumstance of the case and the nature of the offense as also the character of the offender, we think it expedient to release the appellant on probation of good conduct for a period of 1 year from today. His sentence of imprisonment shall remain suspended during this period. He is already on bail and shall continue to be so, provided he executes a bond to the satisfaction of the session judge, Hoshiarpur, the trial court, within 2 weeks from today, with or without sureties, as that court may direct, to appear and receive sentence when called upon during the said period of 1 year. In the meantime, the appellant must keep peace and be good behavior. The sentence of imprisonment shall stand permitted if he does so. The appeal is accordingly disposed of in sound. In the herein, the grievous hurt was caused. Punishment provided under the provision is 7 years. So this judgment provides this honorable court to deal with the matter and no extend the PO Act. And another Supreme Court judgment, another judgment is also there. 477 and 120B. One of the offenses common in that matter. Today. And apart from that, the offense has not been completed. Just they produced the marks card. Nobody established that whether the fabrication of the marks card by the petition, only presumption was drawn that the accused persons have fabricated the marks cards. That too pertain to the SSLC one, which were not required for consideration or selection of teachers. Teachers course, teacher training course and certificate was necessary for selection of primary school teachers. Nowhere notifications were produced. The prosecution has not established the guilt of the petitioners before the trial court. Production of document itself does not constitute the offense. So apart from that, my request before your lordship, since the punishment is up to 1 year in all the offense for all the offenses, and they may be extended, the provision of PO for benefit of PO Act can be extended. And apart from that, one more point for consideration, your lordship, they did not get any employment after this one. Now they become just in agriculture. They are doing coolly in spite of that completed their teacher training course and all these things.
What is the material produced to show this? The petitioner committed forgery?
No material is.
Fabricating the marks card. Fabricating the marks card. So he was obtained, the original marks is 228 out of 600. So he fabricated the marks, Kannada for 59, he was written fabricated 89. Like that, all the subject, he fabricated more marks. So the total is 368 total. It is fabricated marks. And originally he was obtained only 228 out of 600.
So where did you get the original marks card?
Marks card from the school authority,
The prosecution secured it?
school authority.
Original
And,
mask card
after
has not been
scrutinizing-
secured. Your lordship may kindly see they have taken the certificate from where this particular candidates have studied it. They are required to secure the original mask card from the SSLC board. They have not secured such mask card from the SSLC board. Just because one marks is varying in this one general science, so far as first petition 705 concern, they sent one of his PT master, physical education master, to the school where the petitioner was studied, and the headmaster has given a certificate that as per their record they maintained, this marker is different from the marks shown in the marks card. Even for a moment, it is admitted that the marks is fabricated. So far as prosecution concerned, the criminal of guilt has to be established that particularly this person has fabricated. Whether it's a mistake has been committed by this one SSLC board or by the school, which while issuing the certificates, this has not been forthcoming on record. And more particularly, the offense was said to have committed in the year 1997. They lodged the complaint on 16/7, 21/7/98, 1.5 years.
7/8/99, and the first information.
Yes, my lord. Eight, 7/98 provision list ಮಾಡ್ತಾರೆ.
These boys were how old?
Then 25, 30, less than 30 years.
Teacher's post.
Teacher's post, primary school teacher. So more than 30 years. Say 26 years. Now to 2024. Offense said to have committed in the year 97.
They've been on bail all through.
All through bail.
Not undergone any.
Not
sentence.
undergone punishment. And another option to this honorable court is, my lord, in some of the cases it has been held. Till rising of the court, the punishment may be imposed and minimum fine will meet the ends of justice. And as well as provision of PO Act.
If your contention is taken, Mr. Gopal Swami,
Please.
that though prosecution may not have produced cogent material to show the
Definitely.
forgery committed by the accused,
Yes.
who else will do that?
That prosecution has to establish that. It is the burden on the always prosecution to establish. So far as criminal guilt concerned, particular person has committed an offense in particular manner. And apart from that, the offense has not been completed. It's not, they have not secured the job or whatsoever. They produced the document, they rejected. That's all.
No, offense has not been completed. Allah.
Yes, ma'am.
Whether
So
you
far
se-
as 420 concerned,
whether you secure job or whether you meet the ends is not relevant for committing forgery.
even otherwise, only 417 is attracts, not any of the offenses. For producing the false document to secure the employment or to get the benefits out of it. 417.
Read 470.
471. Using as genuine a forged document. Whoever fraudulently or dishonestly uses a genuine any document or electronic record which he knows or has reason to believe to be forged document or electronic record shall be punishable in imprisonment for a manner he had forged such document in electronic record. 465 tara. This is the only offense as per the prosecution case is applicable. In the alternate 465.
So 420 is not applicable.
Not applicable.
Cheating, right, in order
Parallel,
to
cheating.
cheating.
420 is applicable or not?
It is applicable.
How?
Forging the document in order to get
What is the definition of cheating?
420.
There must be a property, there must be interestment, there must be interestment.
Cheating. 420, cheating and thereby dishonestly inducing delivery of property or the making alteration or destruction of a valuable security. In order to secure the job, he forged the documents, marks card.
It's a valuable security. Oscard is not a valuable security.
Or anything ಅಂತಿದೆಯಲ್ರಿ, which is signed, ಅದು ಅವ್ರ ಹತ್ರ ಯಾವ್ದು ಓದ್ತಾ ಇದ್ದಾರೆ ಅದು? Which book, which year book do you have? ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ?
ಇದೆ.
Read cheating.
Cheating 415 definition. 420 is imprisonment, punishment. 415. Whoever by deceiving any person fraudulently or dishonestly induces the person, so deceive to deliver any property to any person, or to consent that any person shall retain any property, or intentionally induces the person so deceive to do or omit to do anything, which you would not do or or omit if you were not so deceived, and which act or omission causes or is likely to cause damage or harm to the person in body, in body, mind, reputation, or property is said to be cheat. This provision is not applicable. 420 is a provision providing punishment.
Read the explanation.
Explanation. A, by falsely pretending to be the civil services, intentionally deceives the Z.
ಅದಲ್ರಿ. Explanation.
Explanation. A dishonest concealment of facts is a deception with the meaning of this section. Concealment any line. We have not concealed anything. The marks card is given. They are not, nowhere it is in the prosecution case he establishes that I have fabricated, I have changed the marks card.
No, no. Even if you have not fabricated, The marks card reveals different scores of yours
Yes, ma'am.
from what you
I
have,
had no knowledge at all.
you have no knowledge.
I had no knowledge.
So that means
Whatever the marks card issued, I have submitted by the school authority.
No.
That, so far as that concerned, the prosecution has to establish that the very particular person candidate has fabricated it. Just because of he produced the document, it cannot be said that he has fabricated the document. And it is also not the case of the prosecution on record.
who are these witnesses examined?
PW1,
Who are they?
PW.
He is the director.
Examined 20 witnesses.
Yes.
Complainant is
That PW1 is the complainant, joint director. He deposes that the government were called 1,800 teachers post in the year 2000, in the year
Adella
1997.
Pikagila. All that is not required. That is facts that these many posts were called and these appeared and they presented. What is relevant is whether any document was secured of their marks card to show that the original mark card is different and from what these petitioner accused have produced is
a
altered.
different-
Is altered.
Yes,
And who has altered? Who has seen it? How it is attributed to them?
so petitioner accused produced the marks card before the scrutinizing authority. Then they got a doubt and they inquired with the SSLC board. Thereafter,
How you attribute it to the petitioners is what he's trying to say. How you can attribute to them? If somebody else, once the mass card is given or while it is in your custody, if somebody else has done it, how to know? And there is no presumption here.
presumption and the defense was also the same in the cross-examination. Same defense as they has taken.
So prosecution has to prove beyond all reasonable doubt
yes,
that accused is the one who has committed this act. One, if it is in his custody, he has altered it before giving it. Or after it was given, it was taken out from your custody and altered, forged, fabricated.
before
Producing it is done according to you.
yes,
How it is attributed?
fabricated marks card, SSLC marks card, produced before the scrutinizing authority. So thereafter, they inquired with the SSLC board. So there he secured a lesser marks which he has produced before the scrutinized authority. Entirely different. That also it is here. Clearly, PW1 clearly deposes that the marks card was a fake marks card. It is forged marks card. So original marks card is
What do you say about that one more person who has been let go by this court? The revision petition filed. Who had also applied for the very same post.
Your lordship may kindly exhibit P7,000. His name is also appeared in that exhibit P7.
But otherly, he was acquitted for 465, 68, 71.
For the
trial court.
For the perception of the learned.
Different judges.
Different judges, different judges.
Different judge.
Different court, different judge, but allegations, evidence and everything is common.
All these same witnesses.
In all the three cases.
What is the finding arrived there and why he has been acquitted?
I will read. Judgment. That judgment is not with me, but mentioned in this one. Either. A judgment in
Exhibit B19, it is showing the marks secured by the petitioner accused, 368. That is the forged marks card. Exhibit B19.
Point is the accused wanted to become a teacher. Maybe he was ignorant of the fact that he was eligible at 232 out of 600.
Mr. Gopal Swami, do you
Please.
agree with this? That the attempt, if it becomes successful, execution or commission of the offense is happens only then,
Then only the offense,
not in the case of forgery,
not in the case of the forgery.
not in the case of forgery.
Yes.
In the case of
Now,
forgery.
first, in order to establish, say that he has committed an offense,
Yeah,
The prosecution has to establish that he has committed
So that's
forgery.
a different, I'm asking you apart from that. Mere preparation to commit offense is not punishable.
It's
except
also
preparation.
for not under this particular offenses. Attempt to commit an offense is different from commission of offense.
The commission of offense is already taken place by doing forgery. What else further? That will be next stage.
Next stage, he has produced the
Cheating.
document knowingly or unknowingly, the document is forged. Knowingly, unknowingly is produced. Whether the mens rea is there behind commission of this act, whether the particularly whether the petitioner is committed, whether it was necessary for him to commit such a mistake, since there.
Whether necessary or not is not the question. It may not be necessary for the purpose of securing the job.
Then 420 doesn't attract me.
My question is not that.
Please.
420 will come for cheating.
Yes.
420 may not attract. But forgery is an attempt where you have committed an offense of forging the document by
471, that's what I read.
Ah.
That provision is applicable.
Yes. So for that preparation, mere preparation to commit an offense is not punishable except preparation to commit dacoity and to wage war against government.
Adರಲ್ಲಿ dacoit preparation to commit dacoity is not dacoity. But offense is, we cannot say that there is no offense. But he is punishable under different provision, not for dacoity 394 or 97.
394.
Okay. It's also an offense.
But here in forgery, once a document is forged.
Yes, ma'am. That has.
Whether in your custody, whether in the custody of the other person taken, or whether in the custody of court, and whether before presenting it to the court also would amount to forgery.
Yes. But it is forgery definitely. I'm not controverting it. But who has committed forgery? Presumption can be drawn in so far as criminal trial concerned. Unless the prosecution is establishing the act of criminal forgery beyond all reasonable doubts, convicting an individual is, my submission is not proper. So therefore, at this stage of beginning itself, I made a submission. They are entitled to release on probation of offenders act.
Happens to such kind of, it creates a precedent that you commit forgery and you go for probation and get released on probation.
Innೊಂದು judgment ಈ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಮಾಡಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ಜಾಬ್ ಕೂಡ ಸೆಕ್ಯೂರ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. They reported to the job, different case. This court has asked them to suffer the punishment from since morning to evening in the court and impose certain fine. And there are young candidates were there. They were released on.
What were their age?
Age was the same thing, 25, 26, 28.
What is the penalty and other things in for these?
ಇದರಲ್ಲಿ 5,000 ಹಾಕಿದ್ದಾರೆ. ಇದರಲ್ಲಿ penalty 1,000 ಮಾಡಿದ್ದಾರೆ. Provision.
What is the maximum?
Maximum ಇಲ್ಲ. ಕೊಡಿ.
1,000.
Together with fine, ಇಲ್ಲಿ 1,000 ಹಾಕಿದ್ದಾರೆ ಅಷ್ಟೇ.
2,000, 1,000.
ಇದರಲ್ಲಿ ತಾವೊಂದು 5,000 ಹಾಕ್ಬೋದು.
Really, what has happened is 465, 1,000. 468, 2,000. 471, 1,000. 4. Then 420, 2,000. 6,000 is all.
6,000 ಆಗಿ.
And they have not secured any job now.
No, my lord. My submission is if 10,000 penalty is imposed, it will meet the ends of justice. ನಾನು ಕೊಟ್ಟಿರೋ judgment.
We will retain the conviction.
Please.
In, the sentence to be
Please.
modified by imposing cost, sentence of rupees 10,000 for each case.
Instead of imprisonment, it will meet the ends of justice if the cost is imposed. ಅದರಲ್ಲಿ ಒಂದ್ ಮಾಡ್ಬೇಕಾಗ್ತಾವ. Imprisonment ಇರೋದ್ರಿಂದ since morning to evening, let them be present and suffer the imprisonment. They can't be scot free.
What do you say, Mr. CGP? Why they should not enjoy the same benefit as what the other person has got in by this court?
Arising out of the same
Very
incident.
same employment, very same
Notification on the.
notification for the same teacher's post. Teacherಗಳು ಹಿಂಗೆ ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡೋದು?
Not selected.
Many of them are working now. after getting-
Unemployment problem was there so much of anxiety ನಲ್ಲಿ they committed mistakes and is now suffering.
The whole system of grading
Yes,
has to be
definitely.
revamped and changed by the.
Yeah. But unfortunately, day by day, it is increasing. Gravity of crimes and the gravity of mental status of criminal attitude of people.
A lot of suicides are also happening because of this. Merely because of scoring some marks.
Yes,
Does not determine the intelligence of a person.
IQ is different. Scoring marks is
Realized.
different.
Your client is present?
Is not present, I will direct him to present before the court tomorrow or Monday. If the order is passed and directed to appear before this honorable court, I will see that they will be present. And if this honorable court, if they dictate the orders and pronouncement of the same will be posted for the Monday or something, by that time I will keep them.
Two of them, two petitioners.
Two petitions.
ಹಾಗೆ ಮಾಡುವ. Now they are agriculturists now,
Agriculture.
not taken up any employment.
No, my lord, no employment. They're struggling for even they're from
So
training.
their education is only SSLC.
TCH plus training, teacher training course.
TCH ಮಾಡಿದಾರ?
ಮಾಡಿದ್ದಾರೆ ಅದೆಲ್ಲ ಇದೆ ಅದರದ್ದೆಲ್ಲ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ. They were under the apprehension that whether they are receiving the interview or not, or else they were coming in the selection list or not. ಯಾವುದೋ ಸಬ್ಜೆಕ್ಟ್ ಫ್ಯಾಬ್ರಿಕೇಟ್ ಮಾಡಿದ್ರು one subject marks. That in fact they are fools.
The fabrication is with regard to one subject or all subjects?
One first petitioner concern, first petition one subject. Second petitioner two or three subjects, I think. This is one subject. General science. Instead of 30, 60 is written.
You see page 17.
Please.
Page 17, internal page 10 of the judgment of the trial court. ಎಲ್ಲಾದು ಚೇಂಜ್ ಆಗಿದೆಯಲ್ಲ?
ಇಲ್ಲ ಇದರಲ್ಲಿ ಒಂದೇ. First petitioner ಒಂದೇ 705 ನಲ್ಲಿ. Your lordship kindly see judgment ನಲ್ಲಿ under page 12.
Subject.
Page ಯಾವ್ದ್ರಲ್ಲಿ?
Science.
Page internal page 12.
706 ಅಲ್ಲ?
705 ನಲ್ಲಿ.
ಕೊಡಿ ಮಾದು 705.
That is the first matter.
Why you have given me second matter?
Science is altered. Science subject instead of 30.
First matter is 706. First
Seven
matter in the list is 706.
705 I am arguing.
705 ಅಲ್ಲಿ.
705 ನಲ್ಲಿ science item number 5. Judgment page 12.
ಹಾ,
ಎರಡು ಕಾಲಮ್ ಇದೆ. ಅದರಲ್ಲಿ ಕಾಲಮ್ ನಂಬರ್ 5 ನಲ್ಲಿ ಸೈನ್ಸ್ ಮಾರ್ಕ್ಸ್ 30ಕ್ಕೆ 60 ಬರ್ದಿದ್ದಾರೆ. ಉಳಿದಿದ್ದೆಲ್ಲ
ಕನ್ನಡ 71, ಇಂಗ್ಲಿಷ್
ಅಷ್ಟೇ.
38, ಹಿಂದಿ 13, ಮ್ಯಾಥಮೆಟಿಕ್ಸ್ 36, ಸೈನ್ಸ್ 60 ಮಾಡಿದ್ದಾರೆ.
30ನ 60 ಮಾಡಿದ್ದಾರೆ. ಉಳಿದಿದ್ದೆಲ್ಲ ಸರಿಯಾಗಿದೆ.
This is with regard to petitioner
705
Chandrasekhar. But in the other case,
ಅದರ್ ಕೇಸಲ್ಲಿ ಅದು 2-3 ಸಬ್ಜೆಕ್ಟ್ ಚೇಂಜ್ ಆಗಿದೆ.
2-3 ಅಲ್ಲ, ಎಲ್ಲ ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅವರು ಇಷ್ಟ ಬಂದಂಗೆ. ಕನ್ನಡ 59, 89 ಮಾಡಿದ್ದಾರೆ. ಇಂಗ್ಲಿಷ್ 32, 52, ಹಿಂದಿ 13, 23, mathematics 30 has become 60, science 38 has become 68, social science 76,
56.
they made to 76.
They're all then youngsters, my lord. Some people were behind them and assuring them that they will secure the job, and they were in the hands of some third persons.
Total marks is.
Already you keep them present.
Please, ma'am. Monday.
Monday you keep them present. We'll go by this. Release them on probation.
Please.
Increase the fine. Imprisonment for keeping them.
Please.
Otherwise, they will become more hardcore
Yes,
criminals.
I'll keep present.
In view of the judgment rendered in similar case and the PO Act benefit to be given. Learned counsel for the petition. Learned senior counsel.
Yes.
Shri
C.R. Gopal.
C.R. Gopal.
Gopala Swami.
Gopala Swami on behalf of H.J. Ananda.
Now, Bhargav has filed wakalat in behalf
Bhargava.
of Bhargav G.
Ananda is no more in this case,
Is there, is no more in the case.
so it can be deleted.
It can be deleted.
On behalf of Shri Bhargava G is present.
Bhargav.
Bhargav G. Learned HCGP on behalf of state. Petitioner to keep petitioners accused present before the court. List this matter on 23rd. Registry to delete the name of learned counsel H.J. Ananda in the cause list.
In this case, copy is not served to me, my lord.
Copy ಕೊಟ್ಟಿಲ್ವಾ ನಿಮ್ಗೆ? Madam, you have to give her a copy. ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಒಂದು copy? I directed the registry,
Please, I'll
but
take.
did you go to the registry?
To this matter, I don't know, my lord. Yesterday matters, I approached, my lord, please.
Yesterday or different matter?
Yes, my lord. I'll collect this copy, my lord, please.
Registry is directed to furnish one set of copy of the petition free of cost to the learned amicus curiae. List this matter on after vacation.
Next week, any date, my lord.
I'll list it after vacation. You go through the papers. Yes, Mr. Prateek.
This matter pertains to, my lord, case and counter case I argued other day.
Yes.
Please, my lord.
Whether the same
Prosecutor, my lord, can be
prosecutor can conduct a case and counter case.
case and counter. My lord,
What is your say? ನೋಡಿಲ್ಲ.
Not taken instruction. ನೋಡ್ಲಿಲ್ಲ.
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಲ್ಲ, ನೀವು ಓದಬೇಕು. It has to be conducted by the same IO.
Yes,
It has to be conducted by the same court dealing with the trial.
but prosecutors.
Prosecutor has to be different. Makes sense. Because in one case, he'll be, Adam. In one case, he'll be appearing for the complainant.
Yes.
Who is the accused in the other case? Please.
Short accommodation.
So what the courts have held, the,
Please, not as far as not the case and counter case is concerned, not both the courts have not dealt into that.
so at the most, it will have to be sent back.
Not cannot be, not de novo trial cannot be held not now. Not already trial is held, court is not.
No, it is not your case that the investigating officer is not the same,
I was one and the same,
one and the same.
one and the same,
Court which has decided is one and the
one
same.
and the same,
The prosecutor is two different persons.
different. So
Should
therefore,
have been
not
two
the,
different.
please, Milord. So therefore, in view of the Milord, the Oskar Ingapa's case, Milord, if that prejudice the Milord, the rights of the parties, then Milord automatically trial vitiates.
How the act of the court can prejudice the
Because
litigant?
not the, not here, because of the Milord, same prosecutor Milord conducts Milord both the trial. Not obviously Milord, he has been biased Milord.
All right, now we'll start from that change of prosecutor. How the whole case can be set at naught?
Milord, now the evidence is let. Milord, the evidence is given now. Milord, if the lordship Milord sends, Milord, the remands back to Milord to the trial court, then Milord, the whole evidence has to go. Whole evidence, everything will go, Milord. Milord, completely it's like Milord de novo trial.
That may not be permissible is what you say.
That is why, Milord.
So he has also kept quiet till the prosecutor conducted.
But in
because
fact, Milord,
it
there was,
in his favor. He will keep quiet. Accused can keep silent. One small mistake of the prosecution. What a big blunder. Anyway, go through it to see. You also assist the court, please.
But in fact, Milord, I made two decisions, Milord, of this honorable court. One is from 1975 of this honorable court, where this honorable court not clearly held.
Naib Singh. Naib Singh's case.
No, Milord, that is not that Guti Sannai was a state of Karnataka. Where in particular as to Milord, in particular about when there is a Milord, a similar prosecutor for both offense, Milord, what would be the Milord consequence of that?
That is this court's judgment.
How division bench of this court? That's a memo.
Yes, sir.
On the last occasion, place it not page number 4 only there.
No, this Naib Singh's case does not deal with that. It does not deal with that
Please.
aspect of case and counter case. Supreme Court decision which you have relied.
Well, Naeem Singh, Milord, that is not referred in particular as to Milord, in case of 326, Milord. The sentence can be reduced to the extent that Milord, he can be Milord sit in the court for a Milord entire day, Milord, that could be Milord day sufficient for that. Milord, for that reason, Milord, that is placed. In so far as a case and counter case concerned, Milord, that is not the full bench decision of this court in Oskar in Ingapas.
You place the judgment?
Lord, Lord, along with the memo I placed, Lord, memo dated 14/8/24.
Yes.
That in particular deals with, Lord, the case and counter case.
All right.
Whether the same prosecutor, my lord, conducts, my lord, the case and counter case, what would be the effect of that, my lord, that is there in Guti Sannas,
Correct.
also state of
That
Karnataka.
will be riding different horses. Take out that Nathilal was a state of UP 1990 supplementary, SCC 145. Supreme Court has laid down the law in that case. One more, madam, 2001 SCC criminal 387. What does 465 deal with?
Lord, 465, my lord, which can be cured, my lord, that, my lord, power of the, my lord, the court to, my lord, that can be cured. My lord, some, my lord, my lord, irregularities can be cured under 465.
But failure of justice as occasioned.
If it is occasion the failure of justice, my lord, then trial vitiates. If there is only irregularity, that can be cured under section 465.
Why you did not raise this issue at the earliest point of time?
But in fact, not before the trial court also, my lord, the trial court also points out that not there is a case and counter case. There is a case and counter, it is not the case.
Correct, but you are appearing for the accused.
Please.
So when it was conducted by the very same prosecutor, you realized at that time that it was impermissible.
Court was brought to the notice of that, not that there was a case and counter case. As far as not the aspect of not the Oskir Ringapal's case was not brought in.
No, the aspect of Oskira Rangapala, whether such a irregularity was pointed out by you to the trial court when such thing happened.
Lord, there is no mention on that, Lord.
That is what 465 deals with. in determining whether any error, omission, irregularity in any proceedings under this code,
Please.
any error or irregularity in any sanction for the prosecution as occasioned failure of justice, the court shall have regard to the fact whether the objection could and should have been raised at an earlier stage in the proceedings.
Please, my lord, that is in determining whether.
So if you had raised this at the earliest time when the prosecution began, then they could have set right and it was a curable defect probably then.
Lord, if at all it was raised, my lord, before my lord starting of the trial, it could have been my lord curable, even if my lord, if it's in the off way,
Even midway also,
midway also.
but you did not raise that issue.
Not even in the prosecution, not it applies to the prosecution. Prosecution also did not raise that.
We have to assume and presume the prosecution does not know the law. Neither you raised, nor prosecution raised, nor the court altogether
Kept
the
quiet,
three-
my lord.
three
Altogether kept quiet there.
have occasioned failure of justice. And the benefit goes to the accused.
Please. Because it's a question of law, it can be raised at any stage of the.
But here, how to do de novo trial to begin?
That cannot be done, my lord.
It
De novo
cannot be done now at this stage.
That cannot be done, my lord. That cannot be done. Because my lord, all the evidence cannot be set aside. That is why, my lord, the full bench of this court held, my lord, only in case of failure of justice, my lord, then
Full
trial
bench has relied on the guidelines
of the, my lord, Nathilal as well as, my lord, the Sudhir's case.
as well as the Sudhir and others.
South. Both was relied upon and, my lord, the guidelines were given.
What is that? All right, get that judgment. Let us see, read that judgment, Mr. Lakshman. Have you noted down that? Read that judgment. 2001 SEC 387. Will read. Thank God. Don't we have any of this provision in the CRPC incorporated?
Please, my lord, as far as case and counter case. my lord. Not case and counter case is concerned.
Procedural, that is a
But in case
substantive.
of, my lord, only 219, my lord, of the CRPC, my lord, where
That is trying all the cases together,
together.
separately or together and clubbed more than
That is the only
five
where, my lord,
cases or
we-
one transaction and
How-
other.
how-
This has to be incorporated in the CRPC itself by a common inclusion by the legislature or by at least the state amendment.
There is no, my lord, as far as.
Otherwise, this will continue.
No, this is a judgment law now. It is only, my lord, judgment law. Not how procedure should be adopted, my lord, that is, my lord, way back in the, my lord, Nathilal's case, my lord, that is, my lord, going on.
3 decades have passed after the Supreme Court has already laid the law.
Please, my lord.
The Supreme Court does not say that it has to be by 2 different prosecutors. It is that is by the full bench of this court.
Please.
Supreme Court does not say it has to be by 2 different. Supreme Court says that it has to be tried first hear the argument, conduct trial, reserve it for judgment. Then next case, hear the, conduct the trial, hear the arguments, reserve judgment and pass together the judgment. The question of two different prosecutors has come out because of the full bench judgment of this court. Supreme Court in Nathilal's case and Sudhir does not say so. That guidelines is not speaking about two different prosecutors.
Please.
That is probably brought about because of that he cannot ride the horse in two different directions. Full bench judgment is of which year?
Lord, this is of the year 2012.
2012. So that was referred by,
Lord, in fact, Lord, full bench has taken note of, considered Lord Nathilal as well, so Sudhir.
yes, it is taken. Just go through Mr. Lakshman. So what will happen to these proceedings in view of there being an irregularity committed?
Lord, irregularity which occasion failure of justice.
Yes.
Mere irregularity, Lord, that can be
But
protected.
that is curable always.
That is 465, that's curable.
Irregularity now which cannot be turned back.
Please.
You cannot put back.
Only I think, my Lord, there are two circumstances, my Lord, vitiates the trial. My Lord. One is, my Lord, if the trial court passes a judgment relying on the, my Lord, the evidence of other case. In that case also, my Lord, trial vitiates. And another, my Lord, these are circumstances. Only in two circumstances, I think, my Lord, trial vitiates. In other circumstances, my Lord, 465 protects. It protects, my Lord, the entire procedure of the trial. 465, there's a protection.
Sure, the entire thing goes, it vitiates because of that injustice that is caused. And always it is to the benefit of the accused. Artha aitalla? You can go through these judgments, make a note of it, make your submission. And list it on 26th or 27th?
Please, my Lord, 27.
26th. Okay. All right, please. Learned Counsel Shri K. Pradeep KC is present, Learned HCGP is present, call on for the say of Learned HCGP.
Worship 80 appear for the petitioner. Worship place for a short accommodation. Worship.
Either, sir.
Counsel for petitioner 6 times, call on. Baswaraj Kareddy.
Pray for short accommodation, my lord. I'll do it in next week, my lord. It's today we have some inconvenience.
Request of counsel for petitioner. Call on.
1990. 1990, yes, yes.
45.
ಇದು ಬರ್ಕೊಬಿಡಿ ಮೇನ್ ಆಗಿ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಎರಡು ವರ್ಡ್ ಒಂದನೇ ನಾಥಿಲಾಲ್ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಯುಪಿ.
All right. Learned CGP seeks time. List this matter on.
ಸರ್ ನೀವು ಇದನ್ನ ಕೇಸನ್ ಕೌಂಟರ್ ನೋಡಿ
ಇದು ಬರ್ಕೊಳ್ಳಿ ಮೇನ್ ಆಗಿ ಫುಲ್ ಬೆಂಚ್
ಸ್ವಲ್ಪ time ಕೊಡು.
ಎಲ್ಲ ಇದ್ನ
Some other day.
ALR 2012 ಕರ್ನಾಟಕ
26th.
ಕರ್ನಾಟಕ
Hmm.
509.
Shivramu.
ನೋಡಿ ಇದ್ರದ್ದು ಇನ್ನೊಂದು ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ ಇಲ್ಲಿ ನೋಡಿ ಯಾರ ಫೈಲ್ ನೋಡ್ಕೊಬಿಡಿ ಅಲ್ವಾ.
What is this offense?
Not 6 IPC.
Three not six.
Yes.
The application is 227.
Application is dismissed. Filed by the accused number 1.
It's rejected.
Statement of suicide. Not 6.
There's no representation for petitioner. Learner HCGP present. Call on. Fabrication. After vacation. Interim order extended. Mohan.
The petition.
ಏನಿದು offense?
ಇದು 498A
Ah,
506.
who's you opposing you? State. Convicted. Only for 498A.
Both Millard, 498A and 506. Conviction,
506.
yes, Millard, 3 years and 2 years concurrently.
Hmm.
With fine of rupees 10,000.
You're separated?
Yeah, separated, Millard. Long back. Before the incident,
Ah.
the alleged incident, they are living separate.
Three years.
Yes, Millard.
Any other matrimonial proceedings against them?
No instructions with regard to that. Even in proceedings also not stated any other proceedings, matrimonial proceedings. Allegation only the accused husband was living, left the home, and thereafter he used to come back. And she has stated also that husband accused has taken care. The marriage was in the year 2002. But the incident, alleged incident, in the year 2000.
Marriage yavaga?
2002, sorry.
T12-2000. ಮಕ್ಕಳಿದ್ದಾರೆ. One female child is born.
Oh, female. 3/12/2000. And after 7 years of marriage, the false complaint has been lodged against accused.
Now, what is your case?
And my case is, I am taking care of my wife.
When? Now?
Earlier, till.
You have been convicted,
Yes, ma'am.
affirmed by the appellate court.
And the evidence, Millard, all P2 is his maternal, her maternal uncle, complainant's maternal uncle, P2. P3, 5 and 6 also their relative.
PW1 is a wife.
Wife. Millard.
He has supported Mr. Lakshman.
Yes.
Supported
Supported.
PW1.
PW, the complainant.
3 is the neighbor.
What about 2?
2 is maternal uncle.
He
said
also supports.
Supports.
He supports.
What about 3?
3 is
Supports.
Yaar adu neighbor?
they 3, but 3 said that I have not seen the incident. 3, PW3.
4.
4 is
Is one of the major eyewitness and also major.
4 has also Lakshmi Devi.
Hmm.
She only told that, stated that not seen the incident.
Whether she is eyewitness or mother witness?
No, she is not eyewitness.
Henry, Lakshman.
Witness and major witness. We supported the case of prosecution.
Partly.
Yes.
According to prosecution, PW2 is the only eyewitness, her maternal uncle.
What about PW5?
5 is Radha, Srimati Radha, who is a politician, Millard. She is the Jilla Panchayat member.
The victim informed her that her husband was harassing mentally and physically.
She got information and her statement, Millard, evidence.
Supports.
Yes.
PW6.
6 is a brother of PW1 complainant.
He
Supports.
the-
He supports.
Supports.
Naturally, Millard, he is a brother of PW1.
7.
7 and 8 are major witness.
Hmm.
They also supported the case of prosecution. PW10 is the police constable receiving complaint.
9 is constable. PW9.
PW9 PSI,
Police.
police sub-inspector.
He is IO.
Part master, yes, he is conducting part of the investigation.
Investigation.
PSI.
And 10.
10 is the head constable. Received complaint and submitted the FIR.
FIR submitted.
He filed charge sheet.
So IO is PW9.
Yes, Millard.
PW9, yes, PS.
Major, they only collected marriage invitation and photos. Millard.
Yes.
There is no specific allegation against the accused Millards.
In specific allegation.
Regard to any cruelty and the mental torture. Only when she was in Chikmagalur, the accused went and asked to return the LIC bond. And gold ornaments.
What are the acts of cruelty?
Harassing mentally and physically.
ಏನದು ಮೆಂಟಲಿ ಸುಭಿಕ್ರ ಅಂತ ಹೇಳ್ಬಿಟ್ರೆ ಸಾಕ?
That she categorically deposes that in her evidence that the accused very oftenly use it to
Pradima, the
go
exhibits.
out without intimating
1
the
to 8.
king.
Huh?
The accused very oftenly used to go out of the house without intimating the king.
Often going out of the house is cruelty, na?
Not that much. He was harassing mentally and physically and demanding gold ornaments and also LIC bond.
Record those photographs.
Is the lorry driver, that is why.
Being a basic necessity and also harassing.
Is there any injury caused?
Nothing, my lord.
No, my,
Not Mr. HCGP.
no, my lord, there is no injury.
No injury caused.
No, no.
Were you put to any kind of threat?
The assaulting and abusing as per the prosecution.
So what are the material? Where is the medical records for that?
Medical report is not there.
And any of the valuable securities taken away from you?
He was demanding that, sir.
Huh?
As per the prosecution case, he was demanding.
Demand.
Demand.
Where is it? You're not invoked 3 and 4 of DP. You're not invoked section 3 and 4 of the DP Act here. You have invoked only 498A.
Harassment.
ಅದಲ್ಲ
ಹೌದು.
ಬೇರೆ ಏನಾದ್ರು ಇದೆಯಾ?
ಅಷ್ಟೇ 498A.
498A, 506. So after this, they have separated or they are staying together?
No, earlier also
Separated. Divorces happened?
No, nothing.
No,
No divorce.
but they are not staying together.
They are not staying.
You are just saying or you have information?
No, information at on the last occasion when it was listed. But recently, they are not in contact with me. When I called them, they used to not pick up.
No, after the conviction,
Yes, my lords.
he has not undergone any
No,
custody. He
in
has
view
been on
of,
bail.
in view of stay.
Right, so find out, now that stay is there, sometimes they'll be living together. You will not know, like the other day, one case. They are living together happily.
Because of in the
From the
interest
time
of.
of conviction and even prior to that. ಗೊತ್ತಾಗಲ್ಲ. ಏನು ಮೆಟೀರಿಯಲ್ ಇಲ್ಬಿಟ್ರಿ ಇಲ್ಲಿ? Where is the material of harassment? Where is the material to show any injury? Where is the material of any threat, where is any property being taken away of yours? So the mere statement, interested witnesses.
The accused was asking to give the gold ornaments and also LIC.
You Kotra asking.
It's not there. my lord.
No, by thereby asking whether anything harassment is caused and cruelty is meted, because cruelty is defined. Cruelty is defined for 498A.
Demanding for dowry.
Any willful conduct of such a nature likely to drive the woman to commit suicide, cause grave injury, danger to the life, limb, health of the woman, mental or physical. So that has to be established. Harassment, such harassment is with a view to coercing her or any person related to her to meet any unlawful demand of any property, valuable security. Just find out whether they are living together, otherwise it's a futile attempt now here.
Yes.
I'll find out.
You have to read the complaint, read the statement. Otherwise, there is nothing much that is shown unless the prosecution makes out a strong case. Yes, Mr. Lakshman.
Please.
What is the material? Been convicted now for 3 years. Learned counsel for petitioner is present. Counsel for the state learned HCGP, so also learned HCGP. Petitioner counsel to find out whether the parties to the proceedings, that is the accused and the informant complainant, are residing together or whether they have obtained divorce in any court of law. What is the status of the child? Make his submission at the next date of hearing. Follow on. Find out if they are living together, then nothing will survive. Otherwise, you'll have to argue on merits. Find out what is the definition of cruelty and whether the prosecution has met this aspect. Merely by a statement, it will not amount to cruelty. There has to be something more than that.
Yes.
Obliged.
Patil.
Appearing on behalf of Chandrasekhar Patil. Here for respondent in this case, your lordship. The main contention of the petitioner in this case that respondent has not received the check was the main contention.
You argued the matter, is it?
Partly heard, your lordship. It was my.
You're finished.
Yes, your lordship.
My side has been finished here.
All right, so you have to continue.
Yes, your lordship. I want to draw his lord's attention to the first appellant's judgment, your lordship.
So your only contention is the check was not given.
Yes, your lordship. Page number 7 of first.
You are
appellant.
appearing for
A respondent.
complainant.
Yes, your lordship, complainant. 7 of the first appellant court's judgment.
Appellate court judgment,
Yes, Your Lordship.
page number,
7 of the judgment. Paragraph number 16.
yes. So what is the case made out by the accused?
Yes, Your Lordship, check is for 4 lakhs.
This was handed over to Rudresh for chit fund, that is that.
Yes, Your Lordship, yes, Your Lordship. I have only a short submission, Your Lordship,
Ah.
regarding that. In this,
You have already argued that Rudresh has not been examined.
yes, Your Lordship.
He
And
has
also-
not denied the signature.
Your Lordship. And also, in his very own cross-examination, he stated that check does not belong to my bank account and check is, exhibit P1 is not at all mine. The signature is also not mine.
He has stated.
Yes, Your Lordship.
Ah.
I will draw your Lord's attention to that after reading this paragraph, Your
Yes.
Lordship. Page number, paragraph number 16, Your Lordship. ಮೇಲ್ಮನವಿದಾರರ ಪರ ವಕೀಲರ ಮುಖ್ಯವಾದವೇನೆಂದರೆ ಫಿರ್ಯಾದಿದಾರರು ತನ್ನ ಪಾಟಿ ಸವಾಲಿನಲ್ಲಿ ಆರೋಪಿತನ ಕಡೆಯಿಂದ ನಾನು ಆನ್ ಡಿಮ್ಯಾಂಡ್ ಪ್ರಾಮಿಸರಿ ನೋಟನ್ನು ಬರೆದುಕೊಟ್ಟಿರುತ್ತೇನೆ, ಆದರೆ ನಾನು ಚೆಕ್ ಅನ್ನು ಕೊಟ್ಟಿರುವುದಿಲ್ಲ ಅಂತ ನುಡಿದಿದ್ದು, ಚೆಕ್ ಅನ್ನು ಫಿರ್ಯಾದಿ ಆರೋಪಿತನ ಕಡೆಯಿಂದ ಪಡೆದಿಲ್ಲವೆಂದು ಹೇಳಿದ್ದರಿಂದ ಈ ಪ್ರಕರಣ ಮೇಲ್ನೋಟಕ್ಕೆ ನಿಲ್ಲತಕ್ಕದ್ದಲ್ಲ ಅಂತ ಮಂಡಿಸಿರುವ ಮೇಲ್ಮನವಿದಾರರ ಪರ ವಕೀಲರ ವಾದವನ್ನು ಪರಿಶೀಲಿಸಿ ನಿಶಾನೆ P5 ಮತ್ತು 6 ಆನ್ ಡಿಮ್ಯಾಂಡ್ ಪ್ರಾಮಿಸರಿ ನೋಟು ಮತ್ತು ಹಣ ಸಂದಾಯ ರಸೀತಿ ಇವುಗಳನ್ನು ದಿನಾಂಕ 5/2/2009 ಆರೋಪಿ ಫಿರ್ಯಾದಿಗೆ ಬರೆದುಕೊಂಡಂತಹ ದಾಖಲೆಯಾಗಿರುತ್ತದೆ. ಈ ದಾಖಲೆ ಬರೆದುಕೊಡುವ ಸಮಯದಲ್ಲಿ ಫಿರ್ಯಾದಿ ಆರೋಪಿಯ ಕಡೆಯಿಂದ ಚೆಕ್ ಅನ್ನು ಪಡೆದುಕೊಂಡಿರುವುದಿಲ್ಲ ಎಂಬುದರ ಬಗ್ಗೆ ಸ್ಪಷ್ಟವಾಗಿ ಕಂಡುಬರುತ್ತದೆ. ದಿಸ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್, ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. ಆದರೆ 3/7/2009 ಆರೋಪಿ ನಿಶಾನೆ P1 ಚೆಕ್ ಅನ್ನು ಬರೆದುಕೊಟ್ಟಿದ್ದರಿಂದ ಆನ್ ಡಿಮ್ಯಾಂಡ್ ಪ್ರಾಮಿಸರಿ ನೋಟು ಬರೆದುಕೊಟ್ಟ ದಿನಾಂಕದಂದು ಫಿರ್ಯಾದಿ ಆರೋಪಿ ಕಡೆಯಿಂದ ಚೆಕ್ ಅನ್ನು ಪಡೆದುಕೊಂಡಿರುವುದಿಲ್ಲ ಎಂಬುದರ ಬಗ್ಗೆ ಸದರಿ ಸಾಕ್ಷಿದಾರರ ಸಾಕ್ಷ್ಯದಿಂದ ಕಂಡುಬರುತ್ತದೆ. My contention is that, your lordship, on the date of receiving, I advanced the loan. On advancing the loan, I have received the receipt, consideration receipt and on-demand promissory note. But only in view of discharging the liability, loan liability, he has given me exhibit P1 on 31/7/2009, your lordship. That is on the different date. And coming to this paragraph, your lordship, the cross-examination part of mine,
PW1.
PW1, your lordship, it is stated that in line number 6, your lordship,
Cross examination ಕೊಡಿ.
page number 6 of that said document, your lordship. A question was put forth to me, your lordship. 6th line, your lordship. ಆರೋಪಿ ನನ್ನಿಂದ 4 ಲಕ್ಷವನ್ನು ಸಾಲವಾಗಿ ಪಡೆದಿದ್ದಾರೆ
ಯಾವ್ದು ಓದ್ತಾ ಇದ್ದೀರಾ ನೀವು?
ಅಲ್ಲಿ ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 6, 6th line.
6, ಇಂಕ್ ಪೇಜ್ 6.
Yes.
This is
ಪಾಟಿ ಸವಾಲು ಶ್ರೀ JP ವಕೀಲರಿಂದ.
that is 2/1/2013.
Yes, your lordship, 2/1/2000.
On that
Next
page.
page,
that
other
is-
page, next page, 6th line.
Ah.
The very own statement was read out by petitioner's counsel.
Yes.
ಆರೋಪಿ ನನ್ನಿಂದ 4 ಲಕ್ಷವನ್ನು ಸಾಲವಾಗಿ ಪಡೆದಿದ್ದಾರೆ ಎಂದು ನಾನು ಅವರಿಂದ ಯಾವುದೇ ದಾಖಲೆಯನ್ನು ಬರೆಸಿಕೊಂಡಿಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. I denied. By answering to that, I said, ಆರೋಪಿ ನನಗೆ DP ನೋಟ್ ಬರೆದುಕೊಟ್ಟಿದ್ದಾರೆ ಎಂದು ಸಾಕ್ಷಿ ಉತ್ತರಿಸುತ್ತಾರೆ, ಆದರೆ ಚೆಕ್ ಅನ್ನು ಪಡೆದಿರುವುದಿಲ್ಲ. That is on that said date, your honor. That was 6 months prior to issuing of the check.
ಆದರೆ ನಾನು
ಚೆಕ್ ಅನ್ನು ಪಡೆದಿರುವುದಿಲ್ಲ. On the date of advancing the loan, the complainant had not received the check from the accused. I have only received consideration receipt and the promissory note. Check was received on much later stage. This was
Read
the only
further.
confusion.
Read further.
Yes, your lordship. ನಿಪಿ 5 ಮತ್ತು 6 ಡಿಪಿ ನೋಟ್ ಮತ್ತು ಹಣ ಸಂದಾಯ ರಸೀತಿಯಲ್ಲಿ ಸಾಕ್ಷಿಗಳ ಪೂರ್ಣ ವಿಳಾಸ ಇಲ್ಲ ಎನ್ನುವುದು ಸರಿ. ನಿಪಿ 5 ಮತ್ತು 6ಗಳನ್ನು ಒಬ್ಬರೇ ಬರೆದಿದ್ದಾರೆ ಎನ್ನುವುದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಆರೋಪಿ ನನಗೆ ಬರೆದು ತಂದು ಕೊಟ್ಟಿದ್ದಾರೆ ಎಂದು ಸಾಕ್ಷಿ ಉತ್ತರಿಸುತ್ತದೆ. ನಿಪಿ 5 ಮತ್ತು 6ಗಳಲ್ಲಿರುವ ಸಹಿಗಳಲ್ಲಿ ಮೇಲ್ನೋಟಕ್ಕೆ ವ್ಯತ್ಯಾಸವಿದೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಅದೇ ರೀತಿ ನಿಪಿ 1 ಚೆಕ್ಕಿನಲ್ಲಿ ಹಾಗೂ ನಿಪಿ 5 ಮತ್ತು 6ಗಳಲ್ಲಿರುವ ಸಹಿ ಮೇಲ್ನೋಟಕ್ಕೆ ವ್ಯತ್ಯಾಸವಿದೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ನಾನು ಯಾವುದೇ ಹಣವನ್ನು ಲೇವಾದೇವಿ ವ್ಯವಹಾರ ಮಾಡುತ್ತಿಲ್ಲ. 31/7/2009 ಆರೋಪಿ ಬಡ್ಡಿಯನ್ನು ಪಾವತಿ ಮಾಡುತ್ತಿದ್ದರು ಎಂದು ನಾನು ಹೇಳಿದ್ದೇನೆ ಎನ್ನುವುದು ಸರಿ. ನನಗೆ ಬಸವರಾಜು, ನರಸಿಂಹಮೂರ್ತಿ ಮತ್ತು ಸಿದ್ದಲಿಂಗಮ್ಮ ಎನ್ನುವವರ ಪರಿಚಯವಿಲ್ಲ. ನಾನು ಬಾಡಿಗೆ ಮನೆಯಲ್ಲಿ ವಾಸವಾಗಿರುತ್ತೇನೆ. ಆರೋಪಿಗೆ ಕೊಟ್ಟ 4 ಲಕ್ಷ ರುಗಳನ್ನು ನಾನು ತಂಗಿಗೆ ಚಿನ್ನದ ಆಭರಣ ಮಾಡಿಸಲು ಕೊಟ್ಟಿದ್ದೆನು. ಆರೋಪಿಗೆ ತುಂಬಾ ಕಷ್ಟ ಇದೆ ಎಂದು ಕೇಳಿದ್ದರಿಂದ ಅವರಿಗೆ ನಾನು ಹಣವನ್ನು ಕೊಟ್ಟಿದ್ದೇನೆ. ನನ್ನ ತಮ್ಮ ಬಾಡಿಗೆ ಕಾರು ಚಾಲಕನಾಗಿದ್ದಾನೆ ಮತ್ತು ನನ್ನ ತಂಗಿ ಗಾರ್ಮೆಂಟ್ಸ್ ನಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಾಳೆ. ನನ್ನ ತಮ್ಮನಿಗೆ ತಿಂಗಳು ಸಂಬಳ ಕೊಡುತ್ತಾರೆ. ಅವನು ಟ್ರಾವೆಲ್ಸ್ ಬಳಿ ಕೆಲಸ ಮಾಡುತ್ತಿಲ್ಲ. And also I want to draw his lordship attention to cross-examination of the accused, your lordship. I may be permitted to read cross-examination part of the accused.
What is the name of the accused?
K.M. Prabhu. Cross-examination part, your lordship. ನಾನು PUC ತನಕ ವ್ಯಾಸಂಗ ಮಾಡಿರುತ್ತೇನೆ. ನನ್ನ ಮನೆಯ ವಿಳಾಸ ಅಂಜನಾಗರ, ಮಾಗಡಿ ಮುಖ್ಯ ರಸ್ತೆ, ಬೆಂಗಳೂರು ಆಗಿರುತ್ತದೆ. ನಾನು ಹಿಂದೆ ಶಿಕ್ಷಕನಾಗಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದು ಈಗ ಪುರೋಹಿತ್ಯ ಮಾಡುತ್ತೇನೆ. ನಾನು ಫಿರ್ಯಾದಿಯಿಂದ ಫೆಬ್ರವರಿ 2009ರಲ್ಲಿ 4 ಲಕ್ಷ ರು ಹಣವನ್ನು ಸಾಲವಾಗಿ ಪಡೆದುಕೊಂಡು ಸದರಿ ಹಣದ ಭದ್ರತೆಗಾಗಿ ಒಂದು ಆನ್ ಡಿಮ್ಯಾಂಡ್ ಪ್ರಾಮಿಸರಿ ನೋಟನ್ನು ಬರೆದುಕೊಟ್ಟಿರುತ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಈ ಡಿನೈಡ್. ನಿಪಿ 5 ದಾಖಲೆಯಲ್ಲಿ ಕಾಣಿಸಿರುವ ಸಹಿ ಮತ್ತು ಎಡಗೈ ಹೆಬ್ಬೆಟ್ಟಿನ ಗುರುತು ನನಗೆ ಸೇರಿದ್ದು ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಫೆಬ್ರವರಿ 2009ರಲ್ಲಿ ನಿವೇದಿತ ಪಾಠಶಾಲೆಯಲ್ಲಿ ಶಿಕ್ಷಕ ವೃತ್ತಿ ಮಾಡುತ್ತಿದ್ದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಫಿರ್ಯಾದಿಗೆ ವಿದ್ಯಾ ನಿವೇದಿತ ಪಾಠಶಾಲೆಯಲ್ಲಿ ಶಿಕ್ಷಕ ವೃತ್ತಿ ಮಾಡುತ್ತಿದ್ದೇನೆ ಎಂದು ನಂಬಿಸಿ ಅವರಿಗೆ ನನ್ನ ಬ್ಯಾಂಕ್ ಪಾಸ್ಬುಕ್ಗಳನ್ನು ಕೊಟ್ಟು ನಂತರ ಸಾಲದ ಹಣ ಪಡೆದಿರುತ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಫಿರ್ಯಾದಿಗೆ ಸಾಲದ ಹಣಕ್ಕೆ ಸುಮಾರು 3 ತಿಂಗಳ ಕಾಲ ಬಡ್ಡಿ ಹಣವನ್ನು ಕೊಟ್ಟು ನಂತರ ಸಾಲ ಮರುಪಾವತಿ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ನಿಪಿ 1 ಚೆಕ್ ಅನ್ನು ಕೊಟ್ಟಿರುತ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ದಿಸ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್, ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. ನಿಪಿ 1 ಚೆಕ್ಕು ನನ್ನ ಬ್ಯಾಂಕ್ ಖಾತೆಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದಲ್ಲ. ನಿಪಿ 1ರ ಮೇಲಿರೋ ಸಹಿ ನನ್ನದೇ ಎಂದರೆ ಸಹಿಯಲ್ಲ. ನಾನೇ ಫಿರ್ಯಾದಿಗೆ ನಿಪಿ 1 ದಾಖಲೆಗೆ ಸಹಿ ಮಾಡಿ ಅದೇ ರೀತಿ ನಿಪಿ 5 ದಾಖಲೆಗೆ ಬರೆದು ಸಹಿ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದರೂ ಸಹ ಈಗ ನನ್ನ ಬಾಧ್ಯತೆಯಿಂದ ತಪ್ಪಿಸಿಕೊಳ್ಳಲು ಇಲ್ಲ ಎಂದು ಸುಳ್ಳು ಸಾಕ್ಷಿ ನುಡಿಯುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. He denied his very own check, your lordship, that it belongs to his bank account. He has denied, and he has taken a defense that the check was issued to Rudresh, and I have colluded with Mr. Rudresh and I have falsely lodged a complaint against him or under 138. In his very own statement, he has denied his instrument.
So where does he take the plea that he has given the check to Rudresh? In the cross-examination?
No, your lordship. His lordship.
No, here in cross-examination of DW1, he denies the account, he denies the check, he denies the signature. Where does he take the plea of the check was given to Rudresh? Where?
I will show it, lordship.
In his own evidence or in cross-examination?
In his own evidence, your lordship.
Where? Read that.
1 minute. Lordship, that is mentioned in the first appellate judgment only.
Where is in the records ಅಲ್ಲಿ judgment ಅಲ್ಲಿ ತಪ್ಪು ಮಾಡಿದ್ರೆ? You have to go by the evidence and the statement. How that has come out in the judgment of the first appeal court? From where?
In the first appellate's judgment, it is clearly mentioned. One paragraph I will read, your lordship.
He's challenging that here.
Allah, even petitioner
First
advocate,
appellate court comes to that conclusion from where?
in his very own arguments, your lordship. Even before this court, has taken a contention that a check was given to Rudresh. ಅವರೇ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ, ನಾವು ಹೇಳೋದಿಲ್ಲ. His very own.
Did you issue legal notice?
Yes.
He has received?
Not received. I mean, it was returned with Shara, not.
No
claimed.
reply, no reply.
Then I again posted with certificate under posting. That was served.
Reply is not given to you.
Reply is not.
So directly complaint is filed.
Yes, your lordship.
You have recorded evidence.
Yes, your lordship.
Cross-examination you have read. In cross-examination, has he stated anything about Rudresh?
No, your lordship. They themselves have submitted before this honorable court on the last occasion that check was given to Rudresh. I have colluded. Also in the judgment, it is also mentioned, your lordship. Paragraph, the page number 7 of that judgment, I may be permitted to read. 7 of first appellate's judgment. ನಿಶಾನೆ P1 ಚೆಕ್.
Para?
Your lordship, paragraph 15, page number 7, your lordship. Page number 7 of that judgment. From very first line. ನಿಶಾನೆ P1 ಚೆಕ್, ನಿಶಾನೆ P5 ಮತ್ತು 6 ಆನ್ ಡಿಮ್ಯಾಂಡ್ ಪ್ರಾಮಿಸರಿ ನೋಟ್ ಮತ್ತು ಹಣ ಸಂದಾಯ ರಸೀತಿ ಇವುಗಳನ್ನು ಆರೋಪಿ ತನ್ನದಲ್ಲ ಅಂತ ಅಲ್ಲಗಳಿರುತ್ತಾನೆ. ಆರೋಪಿಯೊಬ್ಬ ನಿವೃತ್ತ ಶಿಕ್ಷಕನಾಗಿದ್ದು, ಪುರೋಹಿತನಾಗಿದ್ದು, ಅಕ್ಷರ ಬಲ್ಲವನಾಗಿದ್ದು.
No, I didn't get where you're reading. Page number?
7. Of first appellate
Page
judgment.
7.
Appeal.
Appeal 7.
Appeal 29 of 2015.
Correct. That, how many, where is it coming from? Para 15.
Paragraph 15, more specifically, page number 7.
How many lines?
First line. ನಿಶಾನೆ P1 ಚೆಕ್, ನಿಶಾನೆ P5 ಮತ್ತು 6 ಆನ್ ಡಿಮ್ಯಾಂಡ್ ಪ್ರಾಮಿಸರಿ ನೋಟು ಮತ್ತು ಹಣ ಸಂದಾಯ ರಸೀತಿ ಇವುಗಳನ್ನು ಆರೋಪಿ ತನ್ನದಲ್ಲ ಅಂತ ಅಲ್ಲಗಳಿರುತ್ತಾನೆ. ಆರೋಪಿಯೊಬ್ಬ ನಿವೃತ್ತ ಶಿಕ್ಷಕನಾಗಿದ್ದು, ಪುರೋಹಿತನಾಗಿದ್ದು, ಅಕ್ಷರ ಬಲ್ಲವನಾಗಿದ್ದು, ತನ್ನ ಸಾಕ್ಷಿ ಹೇಳಿಕೆಯಲ್ಲಿ ನಿಶಾನೆ P1 ಚೆಕ್, ನಿಶಾನೆ P5 ಮತ್ತು 6 ಆನ್ ಡಿಮ್ಯಾಂಡ್ ಪ್ರಾಮಿಸರಿ ನೋಟು ಮತ್ತು ಹಣ ಸಂದಾಯ ರಸೀತಿಯಲ್ಲಿರುವಂತಹ ಸಹಿ ಮತ್ತು ವಕಾಲತ್ತಲ್ಲಿರುವಂತಹ ಸಹಿಗಳನ್ನು ಪರಿಗಣಿಸಲಾಗಿ ಆರೋಪಿ ತನ್ನ ಸಹಿ ಅಲ್ಲ ಅಂತ ಅಲ್ಲಗಳೆದಿರುವುದನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಇಂತಹ ಸಮಯದಲ್ಲಿ ಆರೋಪಿತನ ನಡತೆಯನ್ನು ಸಹಿತ ಪರಿಗಣಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಎಲ್ಲಿ ತನ್ನ ಸಹಿ ಅಂತ ಒಪ್ಪಿಕೊಂಡರೆ ಪೂರ್ಣ ಹಣ ಕೊಡಬೇಕಾಗುತ್ತದೋ ಎಂದು ಆರೋಪಿ ಸಹಿ ತನ್ನದಾಗಿದ್ದರೂ ಸಹಿತ ತನ್ನದಲ್ಲವೆಂದು ಆರೋಪಿ ಅಲ್ಲಗಳೆದ್ದರಿಂದ ಪರಿಶೀಲಿಸಲಾಗಿ ಇಂತಹ ಸಂದರ್ಭದಲ್ಲಿ ಆರೋಪಿ ತನ್ನ ನಡತೆಯನ್ನು ಸಹಿತ ನ್ಯಾಯಾಲಯವು ಪರಿಗಣಿಸಬೇಕಾಗಿರುತ್ತದೆ. Here they have checked the signature made on the wakalat along with exhibit P1, P5 and P6, your lordship. He has entirely denied those signatures made by him in all 3 documents, that on demand promissory note and consideration receipt. It was cross-checked with the wakalat. Same came to be very same.
Where is he talking about Rudresh?
Rudresh, your lordship.
Padima, the original records. P1. Color P1. So the one exhibit P1 and then on demand.
Yes, your lordship. Your lordship, in his chief examination part. Chief examination of DW1 is stated, ನಾನು ನನ್ನ ಸ್ನೇಹಿತನ ಬಳಿ ಚೀಟಿ ವ್ಯವಹಾರ ಮಾಡುತ್ತಿದ್ದು, ಸದರಿ ವ್ಯವಹಾರದ ಸಂಬಂಧ ಭದ್ರತೆಗಾಗಿ ಸಹಿ ಮಾಡಿದ ಒಂದು ಖಾಲಿ ಚೆಕ್ ಅನ್ನು ರುದ್ರೇಶ್ ಎಂಬ.
That's in chief of D.
In chief of DW1.
Now you are saying.
Just before the cross-examination part, chief of DW1, on 7/5/2014, he himself has stated, taken a defense that he has signed a document to one Rudresh.
ಇನ್ ಚೀಫ್ ಅಲ್ಲಿ ಹೇಳಿದಾರಾ?
ಎಸ್ ಯು ಲಾರ್ಡ್ಶಿಪ್, ನಾನು ನನ್ನ ಸ್ನೇಹಿತನ ಬಳಿ ಚೀಟಿ ವ್ಯವಹಾರ ಮಾಡುತ್ತಿದ್ದು ಸದರಿ ವ್ಯವಹಾರದ ಸಂಬಂಧ ಭದ್ರತೆಗಾಗಿ ಸಹಿ
minute.
ಮಾಡಿದ
Let me get that. Read it.
ನಾನು ನನ್ನ ಸ್ನೇಹಿತನ ಬಳಿ ಚೀಟಿ ವ್ಯವಹಾರ ಮಾಡುತ್ತಿದ್ದು ಸದರಿ ವ್ಯವಹಾರದ ಸಂಬಂಧ ಭದ್ರತೆಗಾಗಿ ಸಹಿ ಮಾಡಿದ ಒಂದು ಖಾಲಿ ಚೆಕ್ ಅನ್ನು ರುದ್ರೇಶ್ ಎಂಬುವವರಿಗೆ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ನನ್ನ ಮತ್ತು ಫಿರ್ಯಾದಿಯ ಮಧ್ಯೆ ಯಾವುದೇ ಹಣಕಾಸಿನ ವ್ಯವಹಾರ ನಡೆದಿಲ್ಲ. ನಾನು ಫಿರ್ಯಾದಿಯಿಂದ ಯಾವುದೇ ರೀತಿಯ ಸಾಲ ಪಡೆದಿಲ್ಲ. ನನಗೆ ಫಿರ್ಯಾದಿಯ ಪರಿಚಯ ಇರುವುದಿಲ್ಲ. ನಾನು ಫಿರ್ಯಾದಿಗೆ ಚೆಕ್ ಅನ್ನು ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. ನಾನು ಫಿರ್ಯಾದಿಗೆ ಚೆಕ್ಕಿನ ಹಣ ಕೊಡಬೇಕಾಗಿಲ್ಲ. ಚೆಕ್ಕಿನ ಮೇಲೆ ಬರೆದಿರುವ ಬರವಣಿಗೆಗಳು ನನ್ನದಲ್ಲ. ಹಾಗಾಗಿ ಈ ದೂರನ್ನು ವಜಾ ಮಾಡಬೇಕಾಗಿ ಕೇಳಿಕೊಳ್ಳುತ್ತೇನೆ. In his cross-examination part, your lordship, next page only, last 4 lines of cross-examination. Very contradictory statement has been made. His very own statement have been denied by him. ನಿಪಿ ಒಂದು ಚೆಕ್ಕು ನನ್ನ ಬ್ಯಾಂಕ್ ಖಾತೆಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದಲ್ಲ. In his chief examination is stated he has handed over his very own check, signed blank check to one Rudresh. The same very own check P1 is in question, your lordship. ನಿಪಿ ಒಂದು ಚೆಕ್ಕು ನನ್ನ ಬ್ಯಾಂಕ್ ಖಾತೆಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದಲ್ಲ. ನಿಪಿ ಒಂದರ ಮೇಲಿರುವ ಸಹಿ ನನ್ನದೇ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನೇ ಫಿರ್ಯಾದಿಗೆ ನಿಪಿ ಒಂದು ದಾಖಲೆಗೆ ಸಹಿ ಮಾಡಿ ಅದೇ ರೀತಿ ನಿಪಿ 5 ದಾಖಲೆ ಬರೆದು ಸಹಿ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದರೂ ಸಹ ಈಗ ನನ್ನ ಬಾಧ್ಯತೆಯಿಂದ ತಪ್ಪಿಸಿಕೊಳ್ಳಲು ಇಲ್ಲ ಎಂದು ಸುಳ್ಳು ಸಾಕ್ಷಿ ನುಡಿಯುತ್ತಿದ್ದಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. I've made a suggestion that you have issued P1, P5 and P6 and only in order to
Everything is denied.
everything is denied in total. And also his very own statements are contradictory in nature.
All right.
The only doubt caused by the petitioner is that I had not received the check. That has been clarified, your lordship. The very own version of contention was taken before the first appellate court as well, and it has been addressed in first appellate court's judgment as well, your lordship. That the check was handed over after 6 months only in order to discharge the legal liability of the petitioner or the accused towards me.
That's all.
Yes, your lordship.
ನಿಮ್ದೇನಾರ you want to say anything? Record.
No, your lordship.
And is this matter on 25th? No further arguments. Both of you.
Grateful.
No representation. Call on. Channa, KM is waiting for this matter. What is this?
138, my lords.
You're for complainant.
I'm for the complainant. my
Please Shetty, Ashok Kumar, you're appearing?
Appearing for the petitioner. A week time may be granted, my lord.
It was not, arguments not started
Not
Not
started.
set.
after vacation.
As you lodge.
The counsel for the petitioner and the respondent. Amicus curiae is present, call on.
I was ready with the matter.
Yeah, good, you're ready. You will not be ready. The stay in granted
21st October.
21st.
ಬೆಳಿಗ್ಗೆನೆ ಕೇಳ್ಬೋದು. ನಾನು ಯಾಕೆ ಕೇಳ್ಬೇಕಿತ್ತು ಇಷ್ಟು? ನೀವು ಬೆಳಿಗ್ಗೆ ಕೇಳಿದ್ರೆ ಆಗಿರೋದು. ನಾನು ಯಾಕೆ ಇಷ್ಟು ಕೇಳ್ಬೇಕು?